All right, I'm ready on Lagon. Oh, I should have brought you all's clients in with the rest of those people so I could make sure they were connected, but nonetheless. Mr. Lagon, I need you to start your video, please. I don't want you to unmute. I want you to start your video, please. Ms. Ritter, I forgot Mr. Copeland was in the breakout room. I guess I do need Ms. Stevenson back. Which case is he here for?
Judge Meyer is here on Royal Douglas and Latoya Garrett under 830.
Okay. All right, I'm ready on Lagon. This is case number 234447401, the people of the state of Michigan versus Thurmond Ward Lagon. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning, Your Honor. May it please court, Todd Kaluzny on behalf of Thurmond Lagon, P55534.
Mr. Lagon, please unmute and state your full name for the court.
Thurmond Ward Lagon Jr.
Thank you. Today is the day set for pretrial conference. How are we proceeding?
Your Honor, can I inquire if Ms. Ritter is going to be handling this case next time, because I want to be able to communicate with her outside of court, give her additional information about my client, and also there's some additional discovery that I have not been tendered that I need to get.
She's my courtroom prosecutor. I'm not sure what you mean by is she going to be handling it next time? She's the prosecutor.
Yeah, what I'm asking is, well, I want to schedule for another pretrial, but I want to be able to contact her outside court, give her additional information about my client and about the situation, and be able to get the discovery that I need.
Okay, so, I mean, I think I answered your question, counsel. She's my courtroom prosecutor.
Okay. All right, Your Honor, what I'm asking for today is an adjournment to this is the first pretrial. I'd like another pretrial, and I want to communicate with the prosecutor in the meantime.
The court will continue a not guilty plea on behalf of Mr. Lagon. Set the matter for final pretrial conference. Court will set a final pretrial conference. Oh, Madam Clerk, I don't have it looks like I left my calendar on my desk, so I'm gonna need you to maybe pull up a little bit more, but a court is gonna set a final pretrial conference for Friday, October the 13th at 9:00 a.m. Discovery should be submitted by September the 13th. Bond will continue with no contact with the complaining witness and anything further.
Yeah, Your Honor, if we do have a resolution prior to October 13th, would we be able to get on your docket?
No, if there's a resolution, it'll be resolved on October 13th.
Okay, and there is no date that's sooner. I don't know that we need that much.
I said, no, I need that much time. I need that much time. This is the court's docket. I need that much time. And the people are going to get 2 months to get the discovery to you. And then my docket says October the 13th.
Okay, thank you, Your Honor.
Okay, and then in the future, counsel, when I answer a question, the first time, I answered the question. You keep asking me again.
I'm sorry, Your Honor. I don't mean to be disrespectful to the court. I've never been in front of this court before, so I
So
apologize if I've offended the court in any way.
you didn't offend me. You didn't offend me. I'm bringing it to your attention. You didn't offend me. I said, no, you couldn't come early. Then you said, are you sure? That's basically what you said. Are you sure? I'm not offended. I'm just letting you know.
Okay, thank you, Your Honor.
Okay. All right. Anything further for the record?
Not from the people, Judge. Thank you.
Nothing further, Your Honor.
Okay, then we're all set until October 13th at 9:00 a.m. Have a great day and stay safe.
Thank you, Your Honor. You too.
You're welcome. Thank you. All right, I'm ready on Lopez Castorina. Ms. Ritter, send Ms. Stevenson a text and tell her I need her to come out for a minute.
Yes, Judge.
Thank you so much.
You're welcome.
All right, this is case number 204447001, the people of the state of Michigan versus Lopez Castorina. Strike that. First name is Kavin, Kavin. Last name Lopez Castorina. Defendant is charged with 1 count of failing to stop at a collision accident. And today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Good morning, Your Honor. Ben Werbling, P64889 on behalf of Mr. Lopez Castorina.
Mr. Lopez Castorina, unmute yourself and then tell the court your name.
Kevin Lopez.
And what about the Castorina part? Is that a part of your name?
Yeah, Kevin Lopez Castorena.
Okay, thank you. Today is the date set for a pretrial conference. Mr. Werbling?
Judge, I received the written discovery from Attorney Ritter. I'd like to keep this on a jury trial track, Your Honor. So he's going to continue his not guilty plea.
All right, then the court will enter a not guilty plea. I will set the matter for a final pretrial conference. So Mr. Werbling, let me ask you a question before I give you this final pretrial conference. So you know on the jury trial track, final pretrial conferences are now in February of next year because I don't have any jury trial dates left for this year. So is that what you want me to do, to just give you that February date?
Yes, Your Honor.
Okay. Court will set the matter for a final pretrial conference, February the 9th. And that will be at 9:19. That indicates to the court that you need a jury trial date. Bond will continue. Anything further?
Judge, I just want to know if Mr. Werbling acknowledges discovery from the people.
He said he got discovery.
Oh, he did. I'm sorry.
Yep.
Nothing further.
It was just written discovery. I don't know if there was any video.
No, it was just a paper.
But, yep, I do acknowledge receipt.
Okay, thank you, Judge.
All right, you're welcome. Anything further? All right, then we're all set. Mr. Lopez Castorena, that date is kind of far away. So what you may want to do, if you don't have a mechanism of alerting yourself, or, first of all, of course, make sure you stay in contact with your lawyer. But second of all, you may want to go onto the court's website and sign up for text notifications of your court date. And they will text you, I think it's like 2 weeks before your court date, they'll text you, okay?
Okay, perfect. Thank you.
All right. Have a great day, sir, and stay safe.
Thank you, Your Honor.
All right, you're welcome. Okay, I'm ready on Harper and then Pilgrim. Whoops, he jumped around. Oh, what? Oh, yeah.
Good morning.
Sir, can you start your video, please? Oh, Ms. Stevenson is here. Ms. Stevenson, I needed you to just acknowledge, Mr. Copeland so he could be on his way. Mr. Copeland, good morning. Mr. Copeland?
I'm
There. Okay, good morning. And then Ms. Ritter indicated to the court that Mr. Copeland was here on Garrett and Royal Douglas. Is that correct, Ms. Ritter?
Correct, Judge.
Ms. Stevenson, do you acknowledge Mr. Copeland's presence on those two cases?
I do. Thank you, Your Honor.
All right, Mr. Copeland, then you're all set. Now, Royal Douglas is present, Mr. Copeland. I don't know if you wanted to stay around and see, but I'm just probably going to be giving another final pretrial date.
I'm good. Thank you.
Okay. All right, then you're welcome. Have a great day. Stay safe.
You too.
All right, thank you.
I can go back, Judge.
Yes, you can go back.
Thank you.
Good morning. Can you make me
Good morning.
close? please?
All right, I'm ready on Harper. This is case number 234465601, the people of the state of Michigan versus Todd Harper. The defendant is charged with one count of, it looks like officer neglect or neglect of office. And today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Max Beisel, P7751 for on behalf of the people.
Douglas Gucher on behalf of Todd Harper is present via Zoom, P64722.
And Mr. Harper, unmute yourself and tell the court your name.
Good morning, Todd Harper.
Good morning. All right, today is the date set for a pretrial conference. How are we proceeding?
Your Honor, we would like to have a motion date and then a jury trial date.
Okay, so court will continue a not guilty plea on behalf of Mr. Harper. Set the matter for a final pretrial conference. Now, I'm assuming then, Mr. Gusher, you already have discovery?
I have the written discovery. I believe there's video that we haven't received. They emailed me the video, the reports. I wasn't sure which prosecutor from the Public Integrity Unit would be handling the matter.
Okay.
Contact. So I know we've been in contact with Matt Penny on other issues. And I just haven't asked him about the video, but I'll get in contact with Mr. Bazell here and get the video, I'm sure, rather quickly.
Okay, well, the trial won't be rather quickly, just so you know.
I understand.
Okay. All right, so I don't know if you heard me tell Mr. Werbling, so I can put you on the jury trial track. All of my jury trial dates for this year are gone. I'm into March of next year in setting jury trials for people who are already in line for jury trials, but we're almost caught up. I mean, I know that still sounds like a long way away, but there used to be 175 cases in line for jury trial. Now there are only 60. So we're getting caught up. We're moving some things around. So I will continue a not guilty plea on behalf of Mr. Harper. I will set the matter for a final pretrial conference. I can set that for that same February 9th date at 9/19, putting you on the jury trial track. You'll probably get a jury trial date. Maybe I'm thinking next fall, that will probably be the jury trial date. If my cases keep going the way they are. So is that date good for you?
Yeah, February 9th will work for the defendant, Your Honor.
And does that work for the people?
Yes, Judge.
Okay, so February 9th at 9/19, and then counsel the people will get, of course, any videos or anything prior to that date. And we should be all set. Can I get a little bit of, what is the bond currently? He's on bond, but are there any restrictions to his bond?
It's $10,000 PR bond. I don't believe they put any additional restrictions on him. Todd, did they at the arraignment? I don't recall that.
Can't leave the state. That's the only thing I'm aware of.
Can I get just a little bit of information of what the case is about? Like, from the prosecutor? Not from you, Mr. Gusher. I'm sorry, from the prosecutor.
Yes, Judge. There was an inmate that was being processed. He was able to escape the jail.
Oh, I see.
Right in front of another deputy was chasing after him, asking him to stop. And there's a policy with the Wayne County Sheriff's Department. They must secure the facilities, and he watched and did nothing to attempt to apprehend or anybody else.
So Mr. Harper is already, he was working at the jail.
Yes, Judge, at the time of the events.
Okay, which also means he wasn't carrying a weapon if he was working at the jail. Is that what? Or no, was he carrying a weapon? I don't know, was there any restrictions as to his ability to carry a weapon and work? That's kind of what I'm getting at.
Been suspended pending this at this
Oh,
point.
okay.
He was, I think, 41 days from retirement at the time, but the incident happened in December. They arrested him here in March, or excuse me, in May, and he's been suspended since the arrest date.
Oh, okay. Okay, well, okay. So then, counsel, let me ask you this question. If, so his going back to work is dependent on when this case gets resolved?
I have a motion to dismiss that I need to file on this, but I needed a date for it. And that's what's going to be
Okay, so
the
then
follow-up question.
Let's do this then. I'll keep that February 9th date for a final pretrial conference. However, based upon that information and your desire to file a motion to dismiss, I'll give you a motion date. I'll give you a motion date. So let's do, this is July, August.
Okay, you still talking to me, so you need these.
Well, hold on. So let me say this, the courtroom is loud. Okay. Counsel, do you think you could file your motion by the end of August?
Absolutely.
So let's say that if your motion is filed by August the 31st, then the people would have until September 15th to respond. You would have until September 20th to reply. I could potentially set the motion hearing for September 22nd, I think. I don't have my regular calendar, but I don't think I'm off. I don't think that date is crossed off. So I can set you a motion hearing for September the 22nd at 11 o'clock, if that works.
I want to take that date. Oh, excuse me. Go ahead, Mr. Prosecutor.
I will be off the 22nd of September. And
All
then
right.
I will be off October 2nd through the 6th.
So does the week of the 25th work? Maybe we could do it on the 28th or 29th.
Those dates work for the people, Judge.
Yes,
What
Your
about-
Honor.
Okay, so let's schedule the motion hearing for Friday, the 29th. Motion. September 29th. At 11 o'clock. So the motion to be filed by August 31st. Response by August, wait, August 31st, 7/14/21, by September 15th. And then reply by September 20th. And then motion hearing September 29th. I'm going to give you an email address to please forward your responses to the motions to. My clerk's email is, I hope I'm getting this right. I'm gonna give you the phone number too in case I get this wrong. But his email address is Christopher, common spelling, .Flanagan, FLANAGAN, Christopher.Flanagan at 36districtcourt.org. That's 36th districtcourt.org. Make sure you send those to Mr. Flanagan so that then he'll forward them to me, okay?
Yes, Your Honor.
Anything further for the record?
Just the phone number.
Oh, thank you. 313-965-2295. 965-2295.
Got it. Thank you, Your Honor.
All right, you're welcome. Then everyone have a great day and stay safe.
You too, Your Honor.
You as well. Thank you, Judge.
You're welcome. I'm ready on Pilgrim and then Patterson.
Me.
Hold on, counsel. This is case number 23-446-6701. The people of the state of Michigan versus Ramon Vincent Pilgrim. Defendant is charged with 1 count child abuse, 4th degree, 1 count assault and battery. Today is the date set for pretrial conference. Appearances, please.
The record, Your Honor, Christina Ritter on behalf of the people.
And may it please this honorable court, good morning. Byron Pitts, ready on behalf of Mr. Pilgrim, who consents to having this hearing today by Zoom. Is that true, Mr. Pilgrim?
Unmute yourself, Mr. Pilgrim.
Yes, that is correct. Good morning.
Good morning. And Mr. Pitts, state your P number for the court reporter.
P59079.
Thank you. And Mr. Pilgrim, state your full name for the record.
Ramon Vincenti Pilgrim.
Oh, they left off an E on my docket. Your middle name ends with an E?
No, it ends with an I. It's VENCENTI.
T-I, okay. Well, it's gonna keep getting cut off on my docket, so I'm probably gonna keep getting, I guess they ran out of space, but nonetheless, today is the day set for pretrial conference. Mr. Pitts, how are we proceeding?
Your Honor, I firstly want to acknowledge discovery that I've received from the people. I would respectfully ask for a final pretrial conference be set. I'd like the opportunity to speak with Sister Counsel Ritter on this matter. If I can bring up one thing, Your Honor, we are desirous of trying to resolve this matter as soon as possible. And if we can't do it between the parties, then we'd like to set a trial date. We would be amenable to a bench trial if that would expedite matters.
So, Ms. Ritter.
I'm so sorry, Judge. So actually, this is assigned to APA Makepeace, who's in the waiting room. I just got about it. I'm sorry, Judge.
Okay, no problem.
Your Honor,
APA gonna have to come earlier because we'll be finished with his case before he get here. Okay, so
a prosecutor, Ms. Ritter?
Right. Yeah, that's what she's saying. So apparently, Mr. Makepeace, we were getting ready to almost be finished.
I apologize, Judge. Matthew Makepeace on behalf of the people, P82796. I was watching on the YouTube stream, so I'm up to date on what's happened so far.
Oh, okay. Okay. All right. So then today is day set. So Mr. Pitts, you want
Makepeace.
Final pretrial conference, and then you were indicating that you would not be opposed to a waiver trial.
That is correct, Your Honor.
All right. So this is what I will do. I will continue a not guilty plea on behalf of Mr. Pilgrim. Mr. Makepeace, are there any videos or anything? Mr. Pitts indicated that he did receive paper discovery.
Video too, Judge.
Oh, okay. All right. Thank you. So video too. All right. So I will then continue the matter to a final pretrial conference, and then Mr. Pitts, if at that time you have if the parties have not been able to resolve the matter, then I will inquire as to the waiver on behalf of your client and the people. Okay?
Certainly, Your Honor.
All right. So since you already have discovery, then I could probably fit you in on a final pretrial conference. I think I was saying no more all of the rest of August in my book. So let's go to, maybe I could fit you in on, Madam Clerk, can you tell me how many cases I have on September the 14th or 15th? Does those dates work for both counsel?
That'll work for the people.
That does for me, Your Honor, and certainly understanding the court's schedule, we'll take the first available date you have, and if that's the 14th or the 15th, certainly we'll take that.
Okay, Madam Clerk?
Judge, you have 10 cases on September 14th.
All right, so that means I actually had 20 because the magistrates have put 10. All right, so September 14th does work for the court.
Okay.
So I will set the final pretrial conference for September 14th at 9 o'clock on Zoom. And then if the matter hasn't been resolved, then I'll inquire as to the waiver and get you a waiver date. Okay?
Okay. I've got one last issue, if I may, Your Honor.
You may. Yes, Mr. Pitts.
Your Honor, I'm going to respectfully ask that Mr. Pilgrim be allowed to travel. He has a prearranged trip to the Bahamas. I think it's for a week. I mean, certainly, let me give him his propers. Dr. Pilgrim, he's no flight risk. He is embedded in this community. Certainly, whatever conditions the court wants to put upon him, if the court were willing to allow him to travel. But I wanted to bring it to your attention. I don't know, I don't have the exact dates written down. I believe it's next month. He's got
yes.
Wait until the court allows you to talk, Mr. Pilgrim.
Yes, sir.
Mr. McPeace, do the people have any objection to the court allowing Mr. Pilgrim to travel?
Judge, at this point, in the future, we may not, but at this point, I am going to object. I would like to see some documentation as to flights and that this trip is actually booked and prepaid for. I'm sure the court would like to see that as well before allowing him to travel out of the country. So at this point, I am going to object, but I'm sure we can work this out and get the approval necessary from the court.
And normally, Mr. Pitts, I would not even hesitate, but it is out of the country. So I think I do agree with the people in terms of just verification of the trip. And
Sure.
then I have a question about, because I did now remember the charges. As to the child abuse charge, is the complaining witness in any way related to Dr. Pilgrim, or is this some non-related situation?
Are you addressing me, Your Honor? I'm happy to respond.
The people.
Okay.
Judge, this occurred at a school in a student-teacher relationship, or something similar to that. I'm not familiar with the specific details of the case, but I do know it happened at a Detroit public school.
Okay, so then there's no issue in terms of the child residing. So I'm sure that the bond is no contact with the complaining witness. We'll continue that bond. So this is what Mr. Pitts, you can do. Please email the travel information to me, not to me personally, but to my clerk. And then and once I get the verification, though, counsel, I am, Mr. McPeace is who I'm talking about. I am probably inclined to grant the request. However, I will forward to the both of you. Once I look at it, then I'll forward to the both of you. Mr. Pilgrim, what are the dates of the trip?
The dates are, Your Honor, August 7th through the 11th.
August 7th through the 11th.
Yes.
To the Bahamas. I mean, I know sometimes we think the Bahamas is in the U.S. because we go there so much, but it's outside the U.S. So, what I'm probably going to require are two things: the confirmation of the trip, and then just a copy of his passport. So the court can be, I don't doubt it, but it is out of the country. So once I get that, I'm inclined to let him travel. I don't see any reason. He has retained counsel, and he has retained, some great counsel. But I guess it wouldn't matter if he had retained bold counsel. I guess I would still have to.
Thank you. I appreciate that.
But he's retained Mr. Pitts, and so I don't think he would want any of that to go to waste. and be a fugitive. So just in that, and you're gonna send it to Christopher.Flanagan at 36districtcourt.org. And I hope I said this to the last group, but it's 36th districtcourt.org.
Judge, how do we spell Flanagan?
Flanagan.
G-A-N. Christopher.Flanagan at did you say we spelling out 3 or the number 3?
No, the number 3, 36, the number 3, 36, and then TH District Court.
That Christopher.Flanagan at the number 3, number 6, TH dot, another dot?
No dot.
Okay. 3, the number 3, number 6, TH District Court.
And then .org. So the 36th District Court is,
districtcourt.org.
Okay.
And Mr. Pilgrim knows that he better be back because there are no refunds.
Right. Absolutely. Yes, look, he would have to pay again if he got.
You got that right.
That's right. All right.
Okay,
Anything
Judge.
further?
Not for the people. Thank you, Judge.
Okay, then we're all set. Everyone, gentlemen, have a great day. Stay safe.
Have a great
you, Your Honor.
Thank you so much.
Mr. Werbling, Mr. Werbling, your client is here. Your other client is here. Ms. Spann, I'm confused by Mr. Samuel. Did you all speak to Mr. Samuel?
Judge, I have not spoken to Mr. Samuel. I spoke with Mr. Patterson.
Mr. Samuel, did you speak with the lawyer in the breakout room?
Yes, Ms. Stevenson.
Okay, she must be under a little stress. I'm just glad that he changed the name. All right, I'm gonna bring out, what happened to him? I'm gonna do the jail, Mr. Werbling, and then I'm ready on, wait, that's a city case. My God.
Yeah, I think we had Miss Walker last time.
Okay, Madam Clerk, I need the city. I need Miss Walker.
Okay.
So I'm actually ready on Eric Patterson. All right. Whoops. Okay, this is case number 204470901. The people of the state of Michigan versus Eric Patterson. The defendant is charged with 1 count of mail theft. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
For the record, Your Honor, Malika Spann, P86586 on behalf of defendant. Mr. Patterson. Mr. Patterson, can you state your full name for the record, please?
Eric Patterson.
Thank you, sir. Today is the date set for final pretrial conference. How are we proceeding?
Judge, this is the second scheduling of the pretrial conference and the complaining witness has failed to appear, so I would like to motion for dismissal in this matter.
This is a final pretrial conference. Was the complainant required to appear, Ms. Ritter?
Judge, my notes don't indicate that the complaining witness was required to appear for today's final pretrial conference.
Has the complainant ever appeared?
Judge, I'm double checking right now. I had that we had a pretrial previously, but for whatever reason, my notes, I usually write down if the complainant witness appeared, but I did not write it down last time, so I'm just gonna check.
Let me tell you what happened. Was it me who said, let me tell you what I'm thinking. I shouldn't say, let me tell you what happened. Let me tell you what I'm thinking. I wonder if it was me, if it was I, who said that the people might be able to prove their case without the complaining witness. On a mail theft, it's the complaining witness is the government. And remember, I was surprised that the county was bringing this case as opposed to this being, I didn't know that this was a state crime. And I was thinking if it was mail theft, that it would be a federal crime. And I was confused a little bit, and then I think you told me. So what complaining witness would the people have? I think that's what the issue was last time, and why I said, so maybe what I said was the people needed to determine who their witness was going to be to prove their case. I think maybe that's what I said. Because how does that work? I don't know.
Okay, because there was individual civilian complaining witnesses listed in the documentation that I had at the first pretrial conference.
The police, they don't know who the witness, I mean, what the complaining witness mean. It's almost like, you know, when the medical examiner says the manner of death, manner and cause of death. Manner of death is blunt force trauma, cause of death is homicide. That don't mean homicide. That, I mean, you know, it means medically homicide. So anyway, Ms. Ritter, what, tell me the allegations. Did he steal allegedly take somebody's mail out of their personal mailbox? He could have stole the mail out of the mail carrier's little thing that they have. So that's what I'm asking. You know what I'm saying? Or he could have allegedly, he could be accused of stealing. That's what I meant. Mr. Patterson, you're innocent until proven guilty. Ms. Ritter?
So Judge, the allegations surrounding this case are that there was a dispatch for shots fired in an area. So the police initially investigated that situation, and that's when they ran into Mr. Patterson, who then was detained by the police. And once the police started their investigation with Mr. Patterson, they discovered that there were packages in Mr. Patterson's possession that did not belong to him. So that's how these charges came about. So actually the necessary witnesses for this case would be the police officers opposed to a civilian witness.
Right.
Because the packages belong to the civilian witness that were discovered in Mr. Patterson's possession.
Mm-hmm. So I see the whole fluidness of it. So in fact, the police are necessary witnesses. Police are, so let me actually say this. The police are the complaining witnesses, and I won't require them to come. But those two civilians are probably also necessary witnesses, because the fact of me having somebody else's package in my possession is not a crime until the police call me and say, did you give this person permission to have the package? Because I'm gonna tell you something. I have somebody's package and, oh, I ain't gonna get him. No, I'm gonna tell y'all after the fact. Like somebody could give you permission to have their package. And so that's not a crime. Like the UPS was telling me I could let somebody else come get my package. So you know what I'm saying? So the police are the complainants because they are the discoverers of the information. I mean, of the packages allegedly. And then the other two people would be necessary because they would have to say they didn't give Mr. Patterson permission to have their packages. So that being the case, I am going to deny defense counsel's motion for the dismissal. And therefore, how would you like to proceed? It's the final pretrial. At some point, perhaps the people will have to confirm that those witnesses are available, but I don't look at them as the complaining witnesses.
Understood, Judge. Because the officers are involved, will there be an adjournment to the final pretrial? Otherwise, I would like to stand mute. My client to stand mute, maintain his not guilty plea, and move forward in a jury trial track.
All right, so the court is going to continue a not guilty plea on behalf of Mr. Patterson. Madam Clerk, are you calling for the city attorney?
Yes, Judge, I called the only one.
Okay, thank you. And I will continue the matter to another final pretrial conference, placing Mr. Patterson on the jury trial track. I will set the matter, a final pretrial conference. What date did I get him? For February the 9th. 2024. At 9:19. At that final pretrial conference, I would like the people to indicate something about whether they will actually be able to proceed with jury trial. I know the officers are available, but whatever your proofs need to be in terms of that, because it's not a preliminary examination. So the hearsay statement as to ownership is not admissible in a trial.
Understood, Judge.
And I gave that date assuming that Mr. Patterson is not being held in the Wayne County Jail for this case. Am I correct?
Correct, Your Honor.
Okay. So then we're all set to February 9th at 9:19. Bond will continue. Mr. Patterson, despite where you are, have a great day, sir. Stay safe.
You all too.
Thank you.
Thank you, Judge.
You're welcome. Okay, do we know who this other jail, county jail is, Ms. Seelman?
No. Let me check. I'm checking.
It might be Miss Terry.
Yes, that's what it is, Judge. Yeah.
Can the judge, the judge, did y'all hear me say the judge? Can the jail unmute and tell me who you have?
Good morning, Your Honor, from Wayne County Jail. How are you doing today?
Wonderful, how are you?
Good. We have two people scheduled on our docket with you today. The first one I have a last name Watts, first name Raquan.
Oh, okay.
It looks like he has a review. And we also have last name Terry, first name Khadijah.
All right, Ms. Stevenson, who do you want them to get first for you?
I don't think Miss Terry is gonna need a breakout room, Judge, and I don't know, am I missing something on Raquan Watts for today?
What do you mean?
I don't see him on the docket. Do I have a
Yes, he is.
bad
He's at
docket?
8:20. You do. He's at 8:29.
Okay,
I don't know.
all right. So actually, if he's at 8:29, I'm probably ready on that one too.
Let's see. Did I send you something on him? Let me see. No, I don't have anything on him. But can I get his ROAs, please?
Judge, can you tell me the case number?
He has 3.
Oh, okay. All right.
And I don't see anything from probation. Look, I don't see anything from probation for him.
Okay, he can just go into breakout and then I'll go pull the file from the courtroom.
Okay, so jail, I'm gonna send you to breakout room number, where the jail? Oh, and we need Mr. Watts right now. We don't need Miss Terry. We'll be ready for her. They've already talked to Miss Terry.
Okay, thank you, Your Honor.
All right, thank you. You're welcome. Okay. Ms. Stevenson, let's go ahead and handle Brandywine before you.
Okay.
Oh, and then I can figure out, well, I could do, I'll do Mr. Werbling's client when the city comes. I need the city.
And I think Miss Span can probably do Mr. Watts in the jail, and then I can start putting those cases on the record that are ready, if that's what you want to do, Judge.
Oh, okay, yeah, no, that's fine then. Mm-hmm. I thought you said you was going in the courtroom and get the file. That's why I just said you could do Watts, but
I can get it and send it over. Okay.
You want me to give you all 3 case numbers?
Please, Judge.
Okay, they are all 22044. That's the beginning of all 3 of them. And then he has 14001. They all end in 01. And he has 834 and 286.
Okay. All right. I know I have an old docket too, so I'm gonna chat you the case numbers.
Well, I need everybody to have the right docket.
Yeah, mine is from, oh yeah, July 10th.
That's the other day. So you telling me somebody just added Mr. Watts on my docket at 8:29? Oh, I think I did that. Cause they call, oh, I know who Mr. Watts is. Oh, let me tell you who Mr. Watts, I know who Mr. Watts is. Mr. Watts has been kicked out of specialty court. Mr. Watts has been removed from specialty court. He has absconded every time, and he's been put in jail sometimes, and they try to put him in treatment, and he leave the first day, and all of that. That's who Mr. Watts is. He's coming back to be sentenced from Judge Holmes, and I'm gonna tell you what his sentence is already, so y'all can just know that he's okay. You could talk to him, but that's what's happening with Mr. Watts.
Okay.
Okay. All right. All right. I'm ready on Brandywine. This is case number 234424601. The people of the state of Michigan versus Sharon. Middle name starts with D-A-R-I, and last name is Brandywine. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Sharon Brandywine. Good morning, Ms. Brandywine. Ma'am, please tell the judge your full name.
Sharon Brandywine.
Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, Ms. Brandywine will continue her plea of not guilty. I'm sorry, Judge, just 1/2 a second for me. And I'm going to ask that this matter be placed on jury trial track. Thank you.
Judge, if I may.
You may.
Your Honor, so I did have an opportunity to speak with the complainant witness previously, and my notes indicate that the complainant witness indicated that her and Miss Brandywine resided in the same household at the time of the incident. So I don't know if the court wants to transfer this to the DB docket, but the people believe it should qualify.
Of course I do. The court is going to continue a not guilty plea. On behalf of Ms. Brandywine, I will continue the matter to a final pretrial conference. And I will transfer the case to the docket of Judge Austin Garrett. Madam Clerk, can you get a date from Judge Garrett's clerk?
Yes.
I mean, I don't know how long, is the city in the courtroom?
No, Judge. I'll call back.
All right, let me start letting some other people in.
Honor, the date is July the 28th at 9.
All right, set the matter for July 28th. Before Judge Austin Garrett at 9 o'clock. And Ms. Brandywine, that courtroom is right next door to the courtroom, to my courtroom. It's right next door. And his Zoom ID number is almost the same as mine, except the middle three numbers are 338 instead of 339. Anything further with respect to Ms. Brandywine?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Brandywine. Thank you, Your Honor.
All right, ma'am, you're all set until July 28th before Judge Austin Garrett at 9 a.m. Have a great day and stay safe. Oh, I didn't mean to put up this screen share. I meant to put up this screen share. Mr. Lewis, unmute and state your name. Unmute and state your name.
Tyshawn Burns.
I said, Mr. Lewis. I
King,
want everybody to listen. I want everybody to listen. Mr. Lewis, unmute and state your name.
King Lewis.
Thank you. And then Tyshawn Burns unmuted when not prompted to do so. All right. Chris, unmute and state your name.
My name is Christian Sanders.
Thank you. Well, Ms. Johnson, you're already unmuted. Can you state your name?
Susan Johnson.
Please start your videos.
This is getting on my nerves. Frustrating.
You feel like we all want to hear that, ma'am? You feel like we all want to hear that that's getting on your nerves? Mr. Lewis, please start your video. Ms. Johnson might want to come to court in person. She's frustrated by the Zoom. Mr. Lewis, start your video. Okay, I don't know why Mr. Lewis won't start his video, but I'm going to send you all to a breakout room. I need everyone to remain stationary, seated in an upright position and ready to attend court. You must remain stationary, seated in an upright position, ready to attend court. You must remain seated, stationary in an upright position and ready to attend court. Mr. Barnes is going to go back to the waiting room. Ms. Johnson to breakout room number 7. Mr. Sanders to breakout room number 8. Despite his not turning on his camera, Mr. King is going to go to breakout room.
I turned my camera on. I don't know why it's showing, why it's not showing.
Mr. King, you felt like that was the appropriate to interrupt the court and just say that? Just
I'm sorry.
Go to the breakout room. Go to the breakout room. Mr. Sanders, you're sitting on my screen, but I gave you an invite to go to the breakout room. Please go to the breakout room.
As soon as it came up, Your Honor, it went away.
I need the city. I need the city. Or
Your Honor,
their,
when I call back, she said she texted them, so. I don't
tell
know.
the city of Detroit Law Department that if they don't get to my courtroom, I'm going to dismiss the case. I'm not interested in any text message to a lawyer. I said I need the city.
Oh.
I'm ready on Royal Douglas.
Your Honor, we have the city.
This is case number 224440301, the people of the state of Michigan versus Shirley Royal Douglas. The defendant is charged with 1 count of retail fraud. Today is the date set for pretrial conference appearances.
For the record, John Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Shirley Royal Douglas. Ms. Royal Douglas, ma'am, please tell the judge your full name.
Shirley Amanda Elizabeth Royal Douglas.
Today is the date set for a pretrial conference. How are we proceeding?
Your Honor, we have acknowledged the appearance of the complaining witness for this matter. Therefore, Ms. Royal Douglas will continue her plea of not guilty. We're asking that the matter be set for final pretrial conference, and we would request discovery.
The court is going to continue a not guilty plea on behalf of Ms. Royal Douglas, and I will set the matter for a final pretrial conference. We'll set a final pretrial conference for October the 13th, 2023 at 9:00 a.m. Discovery should be submitted to the defense by September the 13th. Bond will continue with no contact with any Meyer. Bond will continue with no contact with any Meyer. Anything further?
No, thank you, Judge.
No, thank you very much, Your Honor.
All right, we're all set until October 13th. Ma'am, have a great day and stay safe. Mr. Werbling, I'm ready on Crawford.
Judge.
This is case number 20443-900, strike that. 20443-0701, the people of the state of Michigan versus Reginald Crawford Jr. The defendant is charged with 3 counts of scrap tires. Today is the date set for a final pretrial conference. Appearances, please.
May it please the honorable court, Dante Goss, P60162 on behalf of the people.
Good morning, Your Honor. Ben Werbling, P64889 on behalf of Mr. Crawford.
Mr. Crawford, unmute and state your name.
Reginald Crawford Jr.
Thank you. Today is the day set for a final pretrial conference. Mr. Werbling, how are we proceeding?
Judge, my client would like this to be on the jury trial track.
All right, the court is going to set this matter for a jury trial. This is the city, and I will be setting the matter on a Friday. Ms. Ritter, Ms. Silman, we will have to contact Mr. Navin to let him know that, I can't start it on a Friday though. So I have to start it on I could start it on a Thursday. I think it'll have to be on a Thursday then. Let me call Mr. Navin. Give me 1 second.
Yeah, we can actually do it Monday. Absolutely. Okay. No problem.
Okay, so I can keep it on a Friday for the city. So, Madam Clerk,
Yes.
let's go down the Fridays in September. Let's go to the end of September. Let's go to September the 22nd or the 29th. Can you tell me how many cases I have on September 22nd or 29th?
September the 22nd, you only have 4 cases. And let's see. And the 29th, you have 12 cases.
All right. What about also October 6th?
And October 6th, you have 6.
Okay. Those are the 3 choices of dates for this jury trial. I'm assuming that this is going to be a 1-day jury trial because it's little. We could pick the jury in the morning, first thing, and then so as for Mr. Werbling, does any one of those dates not work for you?
The 29th, I'll be out of town, so October 6th would be preferable, Your Honor.
Mr. Goss, I don't know if you'll be the one trying the case, but does October 6th work for you?
I don't know who will be trying the case, but someone will be here, so October 6th is fine.
Okay, the court is going to set this matter for jury trial at 9:00 a.m. Jury trial, and this is Crawford. All right. Are we in need of any final pretrial? It seems like Ms. Crawford is pretty set on this, and obviously I'm assuming the people made an offer today that was rejected, or sent some information today and the offer was rejected. Mr. Werbling?
No, there hasn't been there's been no discussion, Your Honor. But my client's been adamant that, He wants his day in court.
Okay, well then, we're gonna give him his day in court. So it's gonna be October 6th at 9 o'clock. Mr. Crawford, you can ready to say something. Unmute though, because you're muted. Uh-oh, he froze up at that moment. Oh, there it is. Okay.
I just want to say, is there anything else I can do? I've been coming to court for like 2 years.
I don't know what you mean by, is there anything else I could do? Your lawyer just said you want your day in court. Did the people make an offer, Mr. Goss?
Your Honor, the standard offer is a 12-month delayed sentence in this matter, Your Honor, plus any costs.
And
So that would
then he had 3 counts. So would there be any dismissal of any counts in the offer, or he's pleading to 3 counts?
Dismiss 2 of the counts. Lead to 1 dismissal, 12-month delay.
Mr. Werbling, that's the offer. I'll put your client in a breakout room. I don't really know what he means is about if there's anything else I could do. It's all, of course, there's something else we could do. We could go to trial, or we could take a plea, or the people could dismiss. And the people aren't dismissing. Is if Mr. Crawford want to take a plea, then we could do that. So I'll send him to a breakout room and you can discuss. Hold on, don't overtalk me. I'm going to send him to a breakout room and you can discuss it with him, and then you come back out and let me know what he wants to do, okay?
Yes, Your Honor.
I'm ready on Caldwell. Who's doing Caldwell? Ms. Span?
Yes, Judge.
I'm ready on Caldwell. Are you ready on Caldwell?
Judge, yes. I'll do Caldwell. Oh,
there's
Attorney
that.
Stevenson is back. She can take Caldwell. That's fine. I'm ready on Johnson.
Who is John? Oh, yeah, I'm doing Caldwell, Dunham, and then Johnson.
Okay.
So I can put those on if you want to get Mr. The jail.
I'll take Caldwell. That's fine.
This is case number 154417501. The people of the state of Michigan versus Yolando Lynise, maybe Renes is what's on the docket. Caldwell. Defendant is charged with 1 count of malicious destruction of a building. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
For the record, Your Honor, Malika Span on behalf of the defendant. Ms. Caldwell, can you state your full name for the record, please, and unmute?
Yolando Lynise Caldwell.
Today is the date set for a pretrial conference. How are we proceeding?
Judge, we would like to motion for dismissal in this matter for the complaining witness failure to appear.
Ms. Ritter?
Judge, it's at least the second scheduling of this pretrial conference, and the court required the complaining witness, Ms. Tiffany Davis, to be present for today's pretrial conference. I don't see anyone in the waiting room by that name, Judge. I know there may be an unidentified device in the waiting room. If that is not Ms. Davis, I have no explanation as to why she is not present, and at this time, we will not be able to proceed.
Today is the day set for pretrial conference. The complaining witness was required to appear, and it looks like they have failed to appear. There are two unidentified devices. Neither one is connecting to their device. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Ms. Caldwell, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
You as well, Your Honor. Thank you so much.
You're welcome.
Bye-bye.
Thank you, Judge.
You're welcome. Ready on Dunham. This is case number 224414701. The people of the state of Michigan versus Joytanya Dunham. Defendant is charged with 1 count of assault aggravated. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Joytanya Dunham. Ms. Dunham, ma'am, go ahead and unmute and please tell the judge your full name.
Joytanya Irene Dunham.
Thank you. Today is the day set for a final pretrial conference. Strike that, for a pretrial conference. How are we proceeding?
On behalf of Ms. Dunham, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Judge, just at least the second scheduling of the pretrial conference, the court required the complainant witness, Ms. Tiana Teamer, to be present. I don't see the complainant witness in the waiting room, Judge, and I don't have an explanation as to why the complainant witness is not present. So at this time, Your Honor, the people will not be able to proceed based on the complainant witness's failure to appear for the second pretrial conference.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear, and the people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Ma'am, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
Thank you. You as well.
Thank you. I'm actually gonna be ready on Samuel. Give me a moment. I'm gonna let Samuel in, but give me a moment. Ms. Seelman,
Yes, Your Honor.
can you look in the register of action and tell me if the Stanley case was transferred next door?
Stanley.
This is case number 146122201. The people of the state of Michigan versus Antoine Lamont Samuel. Defendant is charged with 1 count of driving while license suspended, revoked, or denied. 1 count of operating with a high BAC. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Antoine Samuel. Mr. Samuel Stir, could you please unmute and tell the judge your full name?
Antoine Lamont Samuel.
A lot of noise going on. Samuel, a lot of
Mr. Samuel, please mute, sir.
And well, even if he mutes, I'm trying to figure out how in the world can Mr. Samuel hear what's going on in court? And I know that the notice that he clicked agree to when he first joined Zoom said be in a quiet place. And I'm trying to figure out how he can hear us with all that noise going on in the background. And then that's why the people come on here and accuse me of not saying something. No, I said it, but you had so much noise going on in your background, you didn't hear me. Ms. Stevenson, how are we proceeding?
Your Honor, Mr. Samuel and I have had the opportunity to discuss this matter.
No, no, I am not taking a plea from Mr. Samuel with all the noise going on in the background. Absolutely not.
Thank-
Absolutely.
Okay, continue the plea of not guilty, Your Honor. Ask that the matters be adjourned for final pretrial conference at the court's convenience, of course, Your Honor.
Court is going to continue a not guilty plea on behalf of Mr. Samuel, and my convenience is that Mr. Samuel will come to court in person on Monday. He will not be in a place with loud noise. I don't even know how we, okay, all right. I'll adjourn the case till Monday.
Judge,
Well, now he can't come Monday.
I'm just checking something. I just wanted that may be okay, but just. Okay, actually, that should be fine.
What's Monday's date?
The 17th.
Final pretrial conference adjourned to Monday, July 17th at 9:02 in person, 9:02. Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. Samuel. Thank you, Your Honor.
Mr. Samuel, we're all set till Monday morning. We'll see you down at the court. Have a great day. Be safe. Yeah, that's what I thought. Miss Stanley's case should have been on Judge Garrett's docket.
And it was not transferred, Judge.
So can we please get a date and transfer the case?
Okay, no.
And Mr. Clemens said he was waiting on a date. And the basis of the transfer is my recusal.
Okay. Your Honor, the clerk has stepped away for a second. She'll be right back. They're gonna call me.
Thank you. Can you please? Oh no, Miss O'Driscoll usually sends me something. Hold on, let me check again. Oh, here it is. All right, I'm ready on Kala. Can you all zoom the camera out, please, so I can see better, a little better?
Yes, Your Honor.
That's good. That's good. Thank you. All right, this is case number 224518301. The people of the state of Michigan versus Muhammad. Whoops, hold on. Muhammad. It's cut off the middle name, but it might be. I can't. Don't even try to do it. And then last name Kala, Kahla. Defendant is charged with 1 count of assault or assault and battery. Today is the set for a review. Counsel, your appearance, please.
Good morning, Your Honor. Mustafa Really? Let me retry that again. Sorry, Judge. Good morning, Your Honor. Mustafa Really, P number 83817 on behalf of Muhammad Kala, who's next to my left. Mr. Kala, please state your name.
Good morning. My name is Muhammad Kahana.
All right, good morning. Today is the day set for review. And I do have an update on Mr. Kala. So Mr. Kala was placed on a non-reporting probation for 6 months, a delayed sentence on, I don't know what this means right here, but he has paid all his tickets and his fines, costs, and fees. He is participating in anger management, and they say he's participating. He participates well in the group. As of this report, though, from probation, he's only completed 7 of 9 anger management. Counsel, he has 2 more to go?
You know. She only said yes. Yeah. Judge, my client's telling me that when he went to probation, they told him he only had to do 7, so he completed it based on their direction.
He shouldn't do that. He should complete it based on whatever I said when I sentenced him. But Madam Clerk, do we have his file?
I'm checking now.
That's why we mail him a copy of the order so he can have it for himself and he doesn't have to rely on anybody else. It's what I say.
Thank you. I appreciate it, Judge. Thank you.
Do we have the file?
I'm checking now, Judge. This is quite a bit of files I gotta go through. Check.
Why they not in alphabetical order? Y'all don't.
They go by case. Yeah.
No, that's dumb. That's dumb. That's a dumb filing system. They should go by alphabetical order. I shouldn't have said that's dumb. I should have said that's not a good filing system.
Name is
Muhammad Kala, Kahla.
Yeah, I don't have the file. I'm gonna look one more time.
I'm gonna have to see if they was in alphabetical order. You just would have went to the K's.
Right.
I'm gonna tell the Flanagan switch to change that up and put them in there based on based on alphabetical order. All right, well, I want to see the probation order. I don't know what I said.
I understand, Judge. My client just told me that the order he got from probation said 7 on it. That's why he did 7.
Okay, I have it, Judge.
Okay, can you look and see what the probation order says?
Okay. non-reporting delayed sentence, and the defendant shall not violate any criminal laws in any unit, okay, shall not use or possess any illegal substance, shall not drive without a valid driver's license, complete 9 weeks of anger management.
Yeah, my order says 9, so I don't know who told him 7. Let's give him a copy of the order. And then when did I put him on probation?
This was January the 13th of this year.
Okay, so January 13th, this is his 6 months, but I'll give him another month to finish the last 2 anger management classes. It looks like he's done everything else. So if he completes the last 2 anger management classes, you don't even have to appear for the review council, because he should get a certificate from the class, and then they will, you can forward the certificate to my clerk, and then I can go ahead and dismiss it. But you should check on this day to make sure that we receive the certificate. All right, so let's see. Today is July, and we're going to make sure he gets a copy of my order. I don't know what probation sends out, but my order is what's important. Today is the 14th, so let's come back up. Oh, that's going to be a heavy day for me. Let's put it on my docket for the 18th. I'll put it on for the 18th of August. That's what I mean, 18th of August, and he can finish those 2 classes, and then I will dismiss it.
Okay, and Judge, I just want to reiterate, so if he gets a certificate before the 18th and I send it to your clerk and you guys confirm reception, he doesn't have to appear, correct?
Correct.
Okay, thank you so much, Judge. I appreciate it. Have a good weekend to you and your staff.
All right, you also, counsel.
Take care.
All right.
For the time, you want to come back at 9?
10 o'clock are all my reviews. I don't know who put this on here for that time, but my reviews are at 10 o'clock.
Thank you, Judge. Take care.
You're welcome. Mr. Werbling, looks like you're back.
Yes, Judge.
Is the city there, or do we need to get them back?
No, he's here.
Oh, okay. Right, so back on the record with the people versus Reginald Crawford. Mr. Werbling?
Yes, Judge. Ben Werbling, P648889. I went over the offer with my client extensively. We would continue our not guilty plea.
All right, not good. Continue. Jury trial October 6th. Anything further?
Your Honor, can we get a final pretrial for October 5th?
I guess. I mean, sound like Mr. Crawford is saying he don't care, but he want to go to trial. But I can give you one for October the 5th. Let's see. Oh yeah, because that jury trial is on a Friday. October 5th. Yeah, that's good. So then at least I can see, make sure we're going to need those jurors for October the 6th. Okay?
Yes, Your Honor.
Final pretrial conference, October the 5th at 9:10. Okay?
Thank you.
You're welcome.
Thank you, Your Honor.
You're welcome.
Have a great day.
Have a great day. Stay safe. Great weekend.
You too. Thank you,
All right.
Judge.
You're welcome. Okay, I'm ready on Watts. This is case number 2244. These are case numbers 2244140001, 22-448-3401, 22-442-8601, the people of the state of Michigan versus Raekwon Christopher Watts. Defendant is charged with 1 count of assault or assault and battery in each case. Today is the date set for review. Ms. Span, your appearance, please.
Hello, my name is Raekwon Watts. How you doing, Miss?
I didn't ask you your name yet. Ms. Span, your appearance, please.
Malika Span here on behalf of the defendant, Mr. Watts, who has stated his name for the record.
All right. So Mr. Watts has been returned to my courtroom because he's been kicked out of the specialty court program. I have been informed that Mr. Watts has been violated numerous times, that Mr. Watts refuses to go to treatment, that Mr. Watts continues to walk away from the program, and that he does not want to participate. Ms. Span?
Judge, that is correct. Mr. Watts has had several issues. I believe that the mental health court and that assessment would fit his circumstances much more so than the substance abuse program that he was in.
No, don't let Mr. Watts fool you. That ain't, Mr. Watts was in mental health treatment court. Mental health treatment court is a dual diagnosis court. Judge Holmes is the ultimate expert on specialty courts. Judge Holmes would never have Mr. Watts just somewhere in drug treatment court when he clearly has mental health issues. No, Mr. Watts has been kicked out of mental health treatment court and he cannot go back. And he is here before this court now for revised sentencing because they have kicked him out of the program and he cannot go back to sobriety court, to mental health court, to veterans court, to a community court. He can't go back to none of the specialty courts because they're sick of Mr. Watts walking away and violating, having to be found, having to go to jail. Mr. Watts don't want help. Mr. Watts don't want help. Mr. Watts want to stay on drugs and he want to stay with his mental health issues. He does not want any assistance. Now, another response, Ms. Span?
Well, Mr. Watts would like to start his employment with Burger King. He states that he has had the interview and he looks to work and would like to be released on tether so he could do so.
Mr. Watts is going to get fired from that job on the second day because Mr. Watts is combative and not participating and he keep walking away. And because he did not let Judge Holmes and her staff address his issues, that's why, and look at him, he getting ready to try to call himself on overtalk me, but I am the queen of not being overtalked. I'm the queen of not being overtalked. So we're not going to do that. I'm going to tell you my intention, and then I will allow you and maybe your client to have a response to my intention. It is my intention to revoke Mr. Watts' probation. I am going to sentence him on case number 22-441-4001 to 93 days in the Wayne County Jail. Case number 22-448-3401 to 93 days in the Wayne County Jail. Case number 22-442-8601, 93 days in the Wayne County Jail. That is my intention. Ms. Span, anything further?
Judge, I would just like to request that those run concurrently and he be given credit for any time served.
The 3 cases will run concurrently, and unless the law requires it, I'm not going to run them concurrently. But if the law requires it, then they gonna run concurrently. So I guess I better find out. Mr. Watts, you can unmute. You can unmute.
Judge, I was trying to ask you. Yeah, I got a job interview on the way. And
you should have thought about that when you kept walking away from the program. You should have thought about that job interview when you kept walking away from the program.
I'm not done anything.
Your sentence was to go and participate in mental health treatment court. You have decided that you did not want to do that. Now, what would make me think? What would ever make me think that I was going to be able to do anything with you on probation when you clearly keep walking away from all of the help that we are trying to get you? So that job interview
I'm
is
not on drugs. I'm not on drugs. My daddy gave.
That's why you were in the mental health court. That's why you.
I know my daddy gave me a phone. I got my ID and social security
Yeah, they
card.
told me that your father came up to the place and brought you a bicycle. They told me your father came up to the place and set a bicycle outside of the treatment place, and you got on the bicycle and rode away. Yeah, I know all about it, Mr. Watts. I know all about it. You ain't coming in here with nothing, no whatever. So anyway, court is going to send that. That is my sentence. I have not changed my mind. And then hopefully one day, Mr. Watts' father and whoever else is around him that is accommodating his refusal to get treatment, perhaps those people will stop enabling Mr. Watts to remain where he is. I think the father should be charged with something, but that's just me. But that's my order. I'm revoking probation. He is sentenced to 93 days on each count. I do understand that Judge Holmes at some point gave Mr. Watts 45 days in the Wayne County Jail, but that was for a violation. That was for a violation. Those 45 days do not count toward the 93. The 45 days do not count toward the 93. Look like he just knocked down the jail camera. They probably gonna come get him, and then he gonna have another charge because he went side. Did you see him jump up and then look like he knocked out the jail camera? So the 45 days, he's not getting credit for the 45 days. But if he served any other time outside of the 45 days, then he can get credit for that time.
Thank you, Judge.
You're welcome. I guess they're gonna have to log back Miss Terry on another camera because it looks like Mr. Watts broke their camera. That's what that looked like. Okay. All right, I'm ready on. Let's see. I guess I'm ready on Barnes and Johnson. I'll do Johnson first. I think Johnson was ready first. I'm ready on Johnson and then Barnes. I'm ready on I don't know what else. Okay, let's go. This is case number 234439001, the people of the state of Michigan versus Susan Johnson. The defendant is charged with one count of assault or assault and battery. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Miss Susan Johnson. Ms. Johnson, ma'am, please unmute and tell the judge your full name.
Please unmute. Oh, wait, I might have stopped. Hold on. It ain't your fault because I think I've stopped. Let me, okay, now she can unmute.
Susan Johnson.
Today's the day set for pretrial conference. How are we proceeding?
On behalf of Ms. Johnson, Your Honor, move for dismissal for the complainant's failure to appear.
Ms. Ritter.
Your Honor, I am going to ask the court to deny defense counsel's motion. It looks like the complainant witness in this matter is a minor and actually the 6-year-old daughter of the defendant.
What?
Yes.
You're not telling me that the Wayne County Prosecutor's Office signed a warrant for assault and battery on a 6-year-old minor child of a person?
And Judge, I'm just trying to get an understanding of why it was charged that way. According to the investigator's report, it looks like the complaining witness was at her grandmother's house where the defendant went over to the home and had contact with her daughter. So I don't.
Well, that's horrible. That's a horrible charge being charged. That way that doesn't. Okay. Okay. So the complaining witness is the 6-year-old daughter. Are you sure the complaining witness isn't the grandmother?
I'm sure, Judge.
Miss Ritter. Okay, Miss Ritter is going to say, Judge, I don't work in the warrant signing unit. That's what you get ready to say, but this don't make sense to me.
I'm just trying to get an understanding because I have questions as well. I know the court has questions, but I don't see anything regarding any CPS order where Miss Johnson is not the custodian parent in this case.
But okay, I guess my confusion is, and maybe it's somebody new in the warrant unit. I don't know, but an assault on a child, isn't that automatically child abuse if the child is my child? I guess that's what I don't understand in terms of the charging. If the child is my child and I'm charged with assaulting my own child, that's the very definition of child abuse. So that's confusing me. But nonetheless, I'm not the people and I don't charge, but that seemed like it's confused me. And I don't know, they're both 93-day misdemeanors. Well, depending on what level of child abuse. So they're both 93-day misdemeanors. So that doesn't make sense to me. Nonetheless, I'm going to continue. So the court is going to deny defense counsel's motion. It's the confuser to defense counsel too. We need to charge what's charging. So that doesn't make sense, but okay. So the motion to dismiss is denied. The complaining witness is a very young minor, not even close to 18.
Continue the plea of not guilty, Your Honor. Ask that the matter be set for final pretrial conference. And I don't know if the people already tendered discovery. If they haven't, we would request discovery, Your Honor.
Court is going to continue a not guilty plea, set the matter for a final pretrial conference. Court is going to set the final pretrial conference. For October, what date have I been set? October 13th. At 9:00 a.m. Discovery should be submitted by September the 13th. Bond will continue with no contact with complaining witness.
Thank you, Your Honor.
All right. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Ms. Johnson. Thank you, Your Honor.
All right, ma'am, you're all set until October the 13th. Have a great day. Stay safe.
Thank you.
You're welcome. Madam Clerk, can you see if the jail is gonna log back in with Miss Terry? They might have to find another camera.
Okay, no problem.
All right. Okay, looks like I'm ready on Barnes. And then Ms. Stevenson, are you ready on Clark that's in person?
I am, Your Honor.
Okay.
But Mr. Clark will kind of be with me in my office, if that's okay with the court.
Well, it is, so why is he sitting on my front row then? They was just trying to make sure I didn't forget him.
That's not Mr. Clark.
Oh, well, who else is sitting on my front
That's
row?
Tyrus Johnson, Your Honor.
Oh.
Who?
Okay.
Tyrus Johnson.
Okay.
Oh. Too many cases on docket. I forget to flip over to the next page. Miss Barnes, I need you to come in the court, in the camera. Why am I looking up at somebody's ceiling? Mr. Barnes, okay, I said remain seated, stationary, in upright position, ready to attend court. That's what I said. Y'all gonna stop putting me in situations that I'm not asking to be put into. This is case number 234462701, the people of the state of Michigan versus Tayshawn. Maybe the middle name is DeCarlos, last name Barnes. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Tayshawn Barnes. Mr. Barnes, sir, please unmute and tell the judge your full name.
Tayshawn Carlos Barnes.
Today is the day set for pre-trial conference. How are we proceeding?
Move for dismissal, Your Honor, for the complainant's failure to appear.
Ms. Ritter.
Your Honor, it's at least the second scheduling of the pretrial conference. The court required the complainant witness, Ms. Shonda Thomas, to be present, and I don't see Ms. Thomas in the waiting room at this time, Judge, and I don't have an explanation as to why Ms. Thomas is not present. So at this time, Your Honor, the people will not be able to proceed based on the complainant witness's failure to appear for the second pretrial conference.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Sir, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
Okay, thank you. You too, Judge.
Thank you.
Thank you, Your Honor.
Your Honor.
Yes. Go ahead, Ms. Ritter.
I think.
You talk about that other case?
No,
oh,
the one we just did.
Which one? Barnes?
Yes.
You messed up?
Well, it's not the second scheduling of the pretrial conference.
It has to be. It's at 8:35. Well, I shouldn't say it has to be. We do make mistakes. It appears to be. It's at 8:35. What are you saying? Was it scheduled for an arraignment the first time?
So there was an arraignment on May 10th. And then it was scheduled for, the ROA is confusing, Judge. It was scheduled for a bond redetermination and a final a bond redetermination and a pretrial on May 12th of 2023.
Well, that was inappropriate.
With Judge McConaughey for the bond redetermination and then Your Honor for the pretrial.
But did they appear here for the pretrial? He must didn't appear, and that's what happened. So he probably was maybe he was on my docket for the pretrial. And then I scheduled it for 8:35 because he did not appear.
Okay.
So it still would be the second scheduling.
Yeah. Yeah, you're right, Judge. Okay,
okay, but
I was panicking.
Maybe we wouldn't have known that either because it would have just been on my docket for a pretrial. We probably wouldn't have looked at the register I don't know why they would schedule a bond redetermination and a pretrial on the same day.
Okay, yep, that's correct, Judge.
Yeah, okay. All
Okay.
right, so we're ready on, I'm tired. Let's see. Oh, Lewis is a sentencing. I might have to take a break before I do Lewis. Are you ready on Lewis? He's not here. Oh, yes,
I'm
he is.
ready on Lewis. I didn't put a plus because he didn't have video, so I had him zoom out and zoom back in. So hopefully his
I need
video is
to-
okay now.
I need to look at his PSIR. I saw it, but I gotta look at it again because I don't know if I highlighted anything. All right,
Okay.
so I'm ready on Phillips. There's no plus sign. Did you all talk to Phillips?
Phillips and Gina's Galaxy have not been out of the waiting room.
Okay, so then we're gonna be ready on Sanders and Johnson and Garrett.
I think we just did Johnson.
No, another Johnson, Ms. Stevenson. See, you're not looking at your docket either. Tyrus Johnson, that's in person.
Oh, yep.
It's the heavy docket.
Yep. Sorry about that. Sorry, Mr. Johnson. I see you right there too.
So we'll be ready on Sanders, Johnson, and Clark. Clark, Sanders, and Johnson. So I'll bring these other people in and then we'll do those three. And then I'll take a break to look at Williams. Oh, and Garrett.
Your Honor, excuse me for interrupting.
Is Garrett on my docket?
So Garrett is, yes, she is.
Where? Oh, right.
10:02.
I see it. Okay. Yes, Ms. Silman.
The jail said they're gonna put Terry on. They have to clean up the polycom that the last defendant tore up.
Yeah, I figured it.
He said he's like in 1,000 pieces.
Oh. Now he gonna get malicious destruction of property, Ms. Stevenson.
I'm gonna subpoena the court.
Subpoena me. I won't leave. I'm gonna leave the video up private so we can have it right there on the evidence. I will recuse myself because apparently I'll be a witness. I didn't see him destroy the thing. I just know he went steal. So I figured that the machine got destroyed. That's all. I didn't see him destroy that.
Definitely gonna subpoena the court now that you said that.
Didn't see him. He just froze up. All of a sudden got up out that chair and swung around. So you can subpoena me. I'm gonna leave this tape right up. Let's mark it. Okay. That's what happened when you do something on video, Ms. Stevenson. Okay, let's focus. Let me bring in the unidentifieds. And I'm confused by this phone. I brought it in before. I mean, this here device with the Zoom ID number, but I was confused by that. However, let's try again. Share my screen. See if we can get anybody to connect. Okay, the only one that's connected is Phillips. Can Phillips unmute and state your name?
Yes, Chantal Renee Phillips.
Thank you. Let's see if we can get the other. I'm going to go ahead and send Phillips to a breakout room because I do think once she gets in the breakout room, she will be able to start her camera. So I'm going to send, where's breakout room? Oh, now the Galaxy is started. Can The person on the Galaxy, unmute and state your name.
My name is Gina Whitfield.
Thank you. Ms. Ritter, is this a witness of yours?
No, that's a defendant, man.
Where is it on my docket? Oh, I see. Mhm. Okay, stop unmuting. All right, and then this person with the court Zoom ID number as your screen name, can you unmute and tell the court your name?
Leandre Irving.
Leandre Irving. Oh, Irving, Leandre Irving.
Yes.
Okay, Mr. Irving, you were quite late for court. All right, everyone start your cameras. Oh, really? Oh, maybe they could, okay. I wonder why they did that. All right, everyone start your video. Ms. Stevenson, they brought Miss Terry in person.
Oh, okay.
Chantel Phillips, whatever that is on your head, please remove it. Gina Whitfield, please start your camera. Mr. Irving, you cannot be in a moving vehicle. You cannot be in a moving vehicle.
I'm not driving though. I still can't be in a moving vehicle.
I don't understand why the people always respond to me and say I'm not driving, as if I can't see what side of the car you're sitting on. So here's the thing I say, you cannot be in a moving vehicle. We are in court and we're not moving in vehicles. So I'm gonna send you, sir, sir, okay, please be quiet at this moment. I'm gonna send you all to a breakout room. I need everyone to accept to join the breakout room. And in order to attend court, you must be stationary, seated in an upright position, ready to attend court. In order to attend court, you must be stationary, seated in an upright position, and ready to attend court. Please accept to join the breakout room and then wait for a lawyer to come into the breakout room to speak with you. Wait for a lawyer to come into the breakout room to speak with you. Ms. Whitfield, you are going to accept to join breakout room number 1. Ms. Irving, you are going to accept to join breakout room. Oh, Mr. Irving, I said Miss. Mr. Irving, breakout room number 2. Okay. And then Phillips, breakout room number 3. Okay. And now I'm ready on, well, let me pull up Clark because he was here the other day. So I need his information. I think I left it at work. So I'm going to pull up Clark. Did I send you something on Clark? Did we have a report on Clark?
I don't think so. It was actually adjourned from earlier in the week. So I'm ready on whatever I need to be ready on.
Okay, well, hold on. Let me see. And you said you don't think so?
I don't. Well, you know what? Let me double check. No, I don't think I had anything.
Well, I wonder why that was.
And then I'm going to get Mr.
Oh,
Clark
it's an
in
old
here.
case, and I had pulled up the ROA. That's what happened. I had pulled up the ROA. I needed the ROA again. Okay. Go ahead and get Mr. Clark. I think I just pulled up the ROA. And actually, it might have been, Ms. Silman, do we have the file for Mr. Clark? I think I actually had I might have had his probation order.
Yes, we have,
Yeah, is his original probation order in there? I think I looked at that the other day when I was there.
yes.
Can you scan that to me?
You are referring to the one for 2009.
I am. His
Okay.
probation.
All right, scanning now.
Okay, thank you. Why did Ms. Stevenson disappear from this screen? I thought, didn't I say I was ready on Clark?
You excused her to go get somebody.
Clark.
Okay.
Clark, but she is in the breakout room. I didn't tell her to go to no breakout room. I said I was ready on Clark. All right. Miss Cece, you just be doing whatever you want to do. I know. You
No, I don't. I'm trying to be efficient.
No, you're not, because I said I was ready on Clark, and then I looked on my screen and Miss Stevenson was gone, talking to somebody named Whitfield. I said, that's something right there, but okay, I'm ready on Clark. This is case number. 09. Oops. Okay. 09-637-6901, the people of the state of Michigan versus Shannon Maurice Clark. The defendant is charged with 1 count of controlled substance possession of marijuana. Today is the adjourned date set for review. Appearances, please. Ms. Stevenson.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Shannon Clark. Mr. Clark, sir, please tell the judge your full name.
My name is Shannon Cornelius Maurice Clark.
Thank you. Madam Clerk, I haven't received anything. Did you send it?
It's very.
The computer moving a little slow. Here it comes, Judge.
Well, what I think I saw while she's sending it, because I'm not there in the building today. What I think I saw when I looked at things the other day was that Mr. Clark here, I thought I saw, let me make sure this is the correct case, that Mr. Clark was sentenced to jail or something. But this, let me make sure, guilty. Review date, oh no, 10 days community service, that's what it was. It was 10 days of community service and the marijuana program, and he was supposed to, it was at that time back then, a dismissal under 7411. That was in 2010. I mean, he was sentenced October 1st, 2009, and then it was supposed to be 7411 back then. He does not, if I'm not mistaken, when I looked at the register of action, there was no a probation officer assigned. But again, I don't have it with me. Ms. Stevenson?
So at this point, Your Honor, I agree with the court that in 2009, he was taken under 7411, 10 days community service and the Marijuana Insight Program. Your Honor, Mr. Clark was sentenced to a term, I think he spent, 7 or 8 years in the Michigan Department of Corrections. I do have an MDOC number, but because he's completed his parole and he's been discharged, I can't pull up that case to get the proof of the incarceration. But I am going to ask the court to close the matter at this time, Your Honor. Even without improvement would be fine. Of course, Mr. Clark would not get the benefit of the 7411 dismissal. He, at this point, Your Honor, he doesn't have any source of income. He hasn't been working because he recently had a brain surgery. So we're trying to put together, get the proof of incarceration. I believe that
what years is he saying he was incarcerated?
2010 to 2017, Your Honor, and I do have an MDOC number.
All right. Okay, the court will close the case without improvement. I won't honor the 7411, but I'll accept your representation that he was in the Michigan Department of Corrections. Anything further?
Nothing on behalf of Mr. Clark. Thank you very much, Your Honor.
Then we're all set. Since he doesn't have a probation officer, there's not going to be an actual discharge. He can get a copy of the Register of Action from the clerk if he wants some paperwork showing that it's closed.
Okay, thanks, Judge.
All right, you're welcome. All right, Mr. Clark, you're all set, sir. Have a great day. Stay safe.
Thank you.
Okay, I'm ready on Tyrus Johnson. Why don't I have an update on Tyrus Johnson? Oh, here it is. Did I send? Yes, I forwarded it to you. Okay. This is case number 2045400601. The people of the state of Michigan versus Tyrus Curtis Johnson. The defendant is charged with 1 count of operating while intoxicated. Today is the date set for review. Ms. Stevenson.
Janice Stevenson appearing on behalf of Tyrus Johnson. Mr. Johnson, good morning, sir. Please tell the judge your full name.
Tyrus Curtis Johnson.
Thank you, sir. Today is the date set for review. The court does have a report from probation, and it indicates that Mr. Johnson has completed all of the terms and conditions of his probation, a 15-month probation that I placed him on December 15th, 2023. However, it does note that Mr. Johnson has an active warrant out of Third Circuit Court it's a family court, a family division, and then a civil contempt of court because he didn't show up for jury duty. And it is a bond, a failure to appear for jury service. What? Ms. Stevenson?
I'm trying to see if that is the same place where we were last time.
Oh, no. Well, I'm gonna guarantee you this. I didn't know about a failure to appear for jury duty bond.
Sorry.
Mm-mm.
Okay, well, the halfway point would not be, if I'm counting correctly, until August.
Let's see. December. Oh yeah, this is exactly 7 months. So it would be, I guess, another half month. I wonder how we did that. So here's the situation. Uh-oh. You didn't show up for jury duty. And they issued a warrant for your arrest. I told the people it's a misdemeanor. So you didn't show up for jury duty. What happened? Don't tell me, because it's a warrant for your arrest. Okay. You have a civil contempt of court warrant for your arrest for failure to appear for jury duty. And then you also have a warrant for Third Circuit Court. I'm going to continue the probation to October. You need to clear up both of those warrants. You need to clear up both of those warrants. You need to contact, well, I don't know where his failure to appear for jury duty. That seemed like, is that this case? I'm confused by the case numbers, but
Right.
I don't know where he failed to appear for jury duty. So he needs to contact his probation officer, because she obviously saw this warrant, and find out who has a warrant out for you with a $250 bond for failing to show up for jury duty. Let's continue this case. His halfway point would be in August. I'm going to continue him to September the 15th. Those two warrants need to be cleared up. Anything further?
Your Honor, I'm just gonna direct Mr. Johnson to go and see Ms. O'Driscoll now if she's available, or at least go down to the probation department.
All right. Officer Crafts, show Mr. Johnson where probation is, and then he can see if Miss O'Driscoll is available, or someone is available to tell him about those two warrants.
Yes, Your Honor.
All right. And his time for court on September 15th is 10:00 a.m. Anything further?
No, thank you very much, Your Honor.
All right, then we're all set. Have a great day. Stay safe. I'm ready on Sanders. Right, this is case number 224429301, the people of the state of Michigan versus Kristen Sanders. The defendant is charged with 1 count of larceny, and I'm sorry, Kristen Darnell Sanders. Defendant is charged with 1 count of larceny. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Kristen Sanders. Mr. Sanders, sir, please unmute and tell the judge your full name.
Christian Darnell Sanders.
Thank you. Today is the date set for final pretrial conference. Ms. Stevenson, how are we proceeding?
Your Honor, Mr. Sanders is continuing his plea of not guilty and asking that this matter be scheduled for jury trial.
The court is going to continue a not guilty plea on behalf of Mr. Sanders, and I am setting the matter for jury trial. Court's next jury trial date is Ms. Silman, can you please go to March the 5th? Is I just on my Zoom?
2. You have 2, Judge.
No, I know, yes.
Oh.
Okay. Can you tell me when the final pretrial conference is for Gibson?
Final pretrial. It actually doesn't have a final pretrial on here. It just says jury trial.
I'm not gonna.
Oh, wait. I misspoke. Misspoke. January the 8th.
And the final pretrial conference for Wright.
December the 15th.
Court is going to set jury trial for Mr. Sanders on March the 5th. I am going to set a final pretrial conference. And of course, that jury trial is scheduled at 10:30. I will set his final pretrial conference with Gibson on January the 8th. And if I didn't say so, the court continues the not guilty plea on behalf of Mr. Sanders. And Mr. Sanders, next time you're going to have to face the sun, or it's very dark. Like I can kind of not make out your face. Not guilty, set a final pretrial conference for January 8th of 2024. That final pretrial is at 9:10. And then the jury trial, March 5th. And so between those 3 cases, we will see which one will actually go with respect to that jury trial date. And then if more than one of those is ready for trial, continuing the trial, then I'll just do something with it in terms of requesting another jury that week or something like that, or bumping another trial that may not go, but they're gonna go around that same time.
Okay.
All right, anything for, Bond will continue. Anything further with respect to Mr. Sanders?
No, thank you, George.
Nothing on behalf of Mr. Sanders. Thank you, Your Honor.
All right, then, Mr. Sanders, we're all set until January 8th, and then we'll know for sure if your jury trial is gonna go March 5th, okay?
Yes, ma'am. Thank you so much.
All right, you're welcome. You have a great day. Stay safe.
All right. Thank you. You too.
All right, I'm gonna do Ms. Garrett left. Ms. Stevenson, I'm gonna read this. I'm getting ready to call the case. I'm getting ready to call the Garrett case, and I'm gonna read this, and I'm gonna tell you what I'm getting ready to do with Ms. Garrett.
Okay.
This is case number 194462002. The people of the state of Michigan versus Ayana Monet Garrett. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for her review. Ms. Stevenson, your appearance, please.
Janice Stevenson appearing on behalf of Ayana Garrett.
All right, Ms. Garrett is not present currently. She was in the waiting room. Ms. Garrett does this every time she come to court. She has an excuse. She has internet issues. She comes, she goes, she can't wait, she impatient, all of this. And then that would be almost, I would almost give grace and mercy for that, except when I read this report, I'm tired of Miss Garrett. So you said that she came down to court allegedly with COVID because she didn't want to go to jail. Well, that's not what Ms. McCall said, and we both know that we respect Ms. McCall and that we don't think Ms. McCall would make up anything. Ms. McCall said the defendant reported that she did not want to comply and she would rather go to jail. She said she's tired of us. She don't have nobody take care of her kids. So she can't do the community service. She can't do the marijuana program, and she don't have any money. So I'm going to help her with her requests.
Before you finish that, Judge,
okay.
I think that the court brought to my attention a subsequent conversation that Ms. McCall had with Ms. Garrett after that one.
Where that's at?
Let me see if I can find it.
Because this right here, it says, "Good morning, Your Honor. Last virtual hearing was April 4th. On July 6th, she was instructed to come to court. The probation was reinstated. The defendant reported that she did not want to do this. She wanted to go to jail. She also indicated that the case is hindering her." Oh, you saying right there, she changed her mind about going to jail?
Yes, Judge.
Okay,
Yes.
but she didn't really. You want to know why she didn't change her mind about going to jail?
Yes,
Because
Judge.
she keeps doing everything that's going to put her in jail. I'm sick of Miss Garrett. I'm just going to tell you the truth. I'm sick of Miss Garrett. She's supposed to be in person right now. She was supposed to come in person today. And Miss Garrett came on Zoom. She called you a million times and told Miss McCall that they are testing positive for COVID. Miss Garrett going to jail. I mean, I don't even know what else to say to you, but I'm K.P.S. and Miss Garrett today, and Miss Garrett going to jail. So we'll come back to Miss Garrett at the end of the docket, but it's unacceptable. So if she has COVID and whatever, then she should be sitting up at home with no reason for not being on this Zoom. None. She has nowhere to go and no place to be because she has allegedly has COVID. All right, I'm moving on, and now I'm ready for.
I mean, can I just say in her defense, Judge, I know that she was Zoomed in.
You could try Miss Gibson, but nope, I moved on. I'm
Okay,
capable of
Judge.
Garrett. I'm sick of Miss Garrett. There's no reason. She's at home. Therefore, her device can be plugged into the socket.
That's true, Judge.
Yeah, I know. Ms. Garrett is capious and she's going to jail. Okay. All right. This is, let's see, we're ready on.
Have Shante Frowner out of the waiting room so she can get interviewed.
I'm ready on Whitfield.
Okay.
I mean, you acting like Miss Frowner been sitting in the waiting room. Ms.
No,
Frowner oh yeah, I
she
know.
hasn't.
She just popped in there, so no, she's gonna wait.
Okay.
She's gonna wait a minute. I'm ready on Whitfield. This is case number. I said I was ready on Whitfield. Oh, right here. All right, this is case number 115646901. The people of the state of Michigan versus Gina Marie Whitfield. Defendant is charged with operating with the high BAC, operating operating with high BAC and driving while license suspended, revoked, denied. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Gina Whitfield. Ms. Whitfield, ma'am, please unmute and just say your full name.
Gina Marie Whitfield.
All right, Ms. Whitfield, you don't have to come up to the screen to talk. You can talk from back there.
Oh, okay, I'm sorry.
That's all right. Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, I believe that today the people were to determine whether or not there are necessary witnesses available. If that is not the case, we are moving the matter be dismissed.
Ms. Ritter.
Your Honor, so the court did set this final pretrial conference for today and required the people to confirm the necessary witnesses for this case, Judge. So during the people's preparation for trial, the people tried to contact the Detroit Police Department to confirm whether the arresting officers are still with DPD at the moment, Judge. And due to the age of the case, the necessary officers, which will be the arresting officers in this matter, are no longer with DPD. So we will not be able to move forward with this matter based on that information, Your Honor.
Ms. Stevenson.
Move for dismissal, Your Honor.
Court is going to grant defense counsel's motion and dismiss the matter without prejudice, as the people have indicated that their necessary witnesses are no longer with the Detroit Police Department and apparently are unreachable at this time. Now, we will mail you a copy of the order of dismissal for your records. Have a great day and stay safe.
Thank you, ma'am. Thank you.
All right. Looks like we're getting ready to take a break because there's people in the breakout room that need to be talked to as well. And then I can look through these papers and see where I put Mr. Lewis's PSIR.
Okay.
Ma'am, state your name for me.
Shante Frowner.
Ms. Frowner, what time did you think you were supposed to come to court?
11.
Really? Who told you 11?
I asked my probation officer. She told me 11 a.m. I had it at my Google calendar.
She didn't tell you 11 a.m. Your probation officer did not tell you that Judge Bryant scheduled a review at 11 o'clock.
That's what it said on my Google calendar.
What time did I tell you to come to court when you were last in court?
I don't remember.
Yeah, you need to remember next time because you are an hour and a half late for court.
Well, I apologize.
Well, I accept your apology. You are an hour and a half late for court. And next time I'm not going to hear your case and a warrant is going to go out for your arrest. Start your camera. Please accept to join the breakout room and wait for the lawyer to come in to speak with you.
Okay.
All right, we are on what, Ms. Stevenson, about 10 minutes?
Maximum. Did you send something? Oh, how about that in your waiting room?
No, how
And
about,
so,
she getting ready, she coming into jail. She going to jail. I'm not fooling her. How about it? How about it?
did you
How
send me
about-
anything for Miss Frowner?
Oh, I don't know.
Okay.
Let me just check.
Okay. I'm gonna head on.
Miss Garrett, I already heard your case, and I'm not going to keep doing this with you. I'm not going to keep doing this with you. I'm not. I've tried. I keep trying. I just keep grace. Like Grace just have to keep showing. Stop it, and listen. That's your problem, and that's been your problem from day one. This right here has been your problem. This exchange has been your problem. And the problem is, I don't have to do it. That's the problem for you. I don't have to do this. And the fact that grace has to continue to show up for you, the fact that mercy has to continue to show up for you, it's exhausting. It is completely exhausting. The fact that you're supposed to be in person today and you're saying everybody got COVID, but yet you can't stay in the breakout room, in the waiting room. I'm glad I can't hear what you're saying, because if you're talking some about my phone died, this, that, fifth, the third. I told Miss Stevenson, she at home, she got COVID. She can't go nowhere. That means the device should be plugged into the wall. It's exhausting. I'm completely exhausted. I'm exhausted. Miss Stevenson, do you need her in the breakout room? You already talked to her in the breakout room. What's going on, Miss Garrett? Because again, just like before, I already said she's going to jail. Then she's gonna pop up after I say she's going to jail. Like, I'm sick of this. I'm literally sick of it. Have you already talked to Miss Garrett?
I spoke with her yesterday, Your Honor, but I would like to speak with her briefly about what's been happening this morning.
Okay, because it's ridiculous. It's exhausting. I'm exhausted. Like, I need to get some rest. It's exhausting. We are on a 10-minute break.
Okay, thank you, Your Honor.
You're welcome. Courtney, can you join the breakout room for me, please? I'm ready on Lewis. I want to always say the name. And then I'm ready on, whoops, and then I'm ready on Terry. So can y'all bring her upstairs?
Okay, Judge, they're gonna get it.
Mr. Lewis, can you please start your video? All right, this is case number 20-452-0601, the people of the state of Michigan versus King Kaiser Lewis. The defendant is charged with 1 count of operating while intoxicated with an occupant under the age of 16 and 1 count of driving while license suspended or denied. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of King Lewis. Mr. Lewis, sir, please tell the judge your full name.
King Kaiser Lewis, third.
Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report, are there any additions, deletions, or corrections on behalf of the people?
Judge, the people had an opportunity to review the pre-sentence report. I don't see any additions, deletions, or corrections on our end.
On behalf of the defense.
Thank you, Your Honor. Mr. Lewis and I've had the opportunity to review the pre-sentence investigation report. And we offer the following corrections, Your Honor. Excuse me. So on page 5, in the employment section, that first rate of pay should change to the range is $1,500 to $2,000 monthly. In addition,
say that again.
So the rate of pay for in the employment section,
right?
The rate of pay for the current employment should be $1,500 to $2,000, a range of $1,500 to $2,000.
Based on what?
That's the information which Mr. Lewis provided me at our interview last night.
Well, we're gonna find out why the probation department would write what they wrote.
In addition, Your Honor, on page 7, the second line of that second paragraph, there would be the same change with regard to the income. Other than that, Your Honor, we have no additions, deletions, or corrections. And Mr. Lewis does stand ready for sentencing.
Anything with respect to sentencing on behalf of the people?
Nothing on behalf of the people, Judge. Thank you.
On behalf of the defense?
On behalf of Mr. Lewis, Your Honor, other than the fact that today I would wish Mr. Lewis a happy birthday today. I want the court to know that he did spend 8 days leased in the Wayne County Jail. And I believe that's going to be relevant because I think there's a mandatory minimum in this charge. And I think that Ms. Ritter would correct me if that's wrong. But I'd ask that he be given credit for the 8 days that he served in the Wayne County Jail on this matter, Your Honor. I'm having some technical problems right now, so I just need to ask Mr. Lewis if he has an alcohol tether.
Yes.
Okay, so I know in the substance abuse use and treatment section, Your Honor, it indicates that Mr. Lewis did fail to submit to your analysis. He does have alcohol tether, Your Honor. He does have it on currently. I know that, I'm just going to go ahead and acknowledge that there have been some problems with the alcohol monitoring. So, and I know that Mr. Lewis he had a violation because of the alcohol tether that landed him in jail. I asked the court at that time if it would take off the alcohol tether, and the court absolutely denied that request. So Mr. Lewis, I believe, is ready to take a stab at probation. I don't, maybe because of the problems with your analysis, it might be a case for the sobriety court, but I do believe that Mr. Lewis would lean into the probation, Your Honor, and know that it looks kind of suspicious from the past, but I think he will lean into the probation and just do everything that he can do to be in compliance.
Hold on. Would Mr. Lewis like to make any statement on his own behalf?
Mr. Lewis?
No, not right now. Not this moment.
Court has had an opportunity to review the pre-sentence report. And I make the following observation about the report. Mr. Lewis was recently discharged unsuccessfully from a probation where he had been sentenced with the benefit of HIDA. His HIDA status was revoked and he was unsuccessfully discharged from probation. Mr. Lewis has 3 warrants for his arrest outstanding, and one of them is for contempt of court. It is my opinion that based on his written resume, he is not a good candidate for probation. However, I'm going to give him an opportunity to prove me wrong. I'm going to give him an opportunity to prove me wrong. But let's be clear about this. There's not going to be a lot of grace and mercy. Number one, let me be clear that I don't believe in unsuccessful discharges from probation, except in limited numbers of circumstances, or I should say, closing cases out without improvement after an individual has unsuccessfully completed their probation Probation, it is an alternative to jail. And jail is an alternative to probation. Probation is an alternative to jail, and jail is an alternative to probation. Now, in this particular case, there is a mandatory minimum. I believe it's 30 days. Ms. Ritter, what's the mandatory minimum?
The mandatory minimum for this charge, Your Honor, is 5 days.
Oh, it's only 5 days?
Yes.
Okay. What's the one with mandatory minimum? Oh, no, that's 45 days and I think they rescinded that. The mandatory minimum. I'm thinking of a different charge. Okay, so there's a mandatory minimum of 5 days in this case. So the court is going to impose the following sentence. Probation has recommended a probationary period of 14 months. I'm going to honor that recommendation, and I will sentence you to probation for 14 months. But again, Mr. Lewis, I'm not, grace and mercy is running thin. And I don't know what would cause an individual to think unclearly enough to blow the benefit of HIDA. I don't know what would cause an individual. And I'm hopeful, though, that there will come a time in your life that you have changed yourself so much, your thinking and everything else, that you're going to live to regret, blowing HIDA. What do I mean by that? Because one day I want you to be in such a place that you are successful and leading a very productive life. And then that thing that's on your criminal record is going to come up and you're going to be like, dang it, I was so dumb not to finish that and get that removed from my record. That doesn't mean you can't be, can't be great. But when I'm looking at your resume, you got contempt of court, you got not finishing your probation, and then the other warrant is I don't know, it says a traffic offense, 2, failure to appear at arraignment in 28th District Court, and then some traffic offense in 40th District Court. Let's not have something in 36th District Court as well. Let's not have an additional, I can't be trusted at 36th District Court. It is a great day on the day of your birth to turn that thing around and make some different choices. Mr. King, Mr. Lewis, I don't know why I want to keep calling you Mr. King. I don't know why I keep doing it. Mr. Lewis, I'm a different kind of judge. You may or may not have heard. I do extend grace and mercy. I wouldn't lie to you about that, because I believe in giving people chances after chances after chances. But it's a person right now in my waiting room. Whew, I'm so exhausted with giving her chances. Okay. So I don't want to get exhausted with you and Mr. Lewis. You're starting out with a little less grace and mercy because I see that you already didn't listen to one of my colleagues in the state of Michigan. You already had to have your probation revoked by one of my colleagues. So I'm already coming in with the attitude that he's not going to do this. The difference is with me, I'm not going to close you out without improvement. I'm going to revoke your probation and send you to jail. So let's not do that. Let's not go there. I want to see you succeed. I want you to succeed. So the court is going to accept the 14-month probationary period on counts 3 and 4. They will run concurrently. The 14-month final review date will be September the 13th of 2024. Of course, Mr. Lewis would still be eligible despite his past history. He would be eligible for an early discharge after 7 months. So he would be eligible for discharge in February of 2024. I'm gonna just give him an opportunity to knock it out of the ballpark. I'm not gonna bring him back before the 7 months because I don't know. I feel like I don't want to expend energy and clog up my docket if he's not going to do what he's supposed to do. So nonetheless, you will be eligible at this review date that I'm going to give you. You will be eligible for early discharge if you have done if you have completed the terms and conditions of probation. Now, the thing about this date, Mr. Lewis, is if you haven't completed it, there's no penalty at this first date. There's no penalty. You just don't get the early discharge benefit of it or whatever. And then depending on how much you've done, if you're almost finished, then I'll give you a date shortly after that. But if you haven't done anything, I'm going to just continue you to your final review and see where the chips fall. And then if you get to the final review and you still haven't done anything, then it's just going to probably be a wrap for you, because I'm going to feel like you treating me just like you treated the other judge. So I implore you to please prove me wrong. I like to be wrong when it comes to those type of things. So the midway review date is February the 15th.
Can I ask a question before you do that?
Yes.
I mean, I normally don't go this route, but will he have enough time to get into sobriety court if it's not?
They're not going to take, I don't know if Judge Holmes is going to take him in sobriety court if he was unsuccessfully discharged from a probation, but we can see.
Well, actually, it looks like there may be no, he probably won't be eligible because of the criminal history, the charge.
Well, no, she doesn't go by the charges anymore. She doesn't go by the charge. She goes by the police report. If there's a charge on there, I mean, I can ask, but we can.
Well, I would like that to be available just in case, just in case it's needed.
You saying you want me to go ahead and do it now, or you saying give them the time to see?
Time to see.
Okay. I mean, if he's testing positive, they're gonna, hopefully, I don't know who his probation officer will be, but most of the probation officers are good at violating the person if they're testing positive. So the court is going to, so are you asking me to give him an earlier review date? I don't want to clog up my docket, but you asking me to give him an earlier review date. That's what you're trying to do.
Yes, I am, Your Honor.
I know, but Ms. Stevenson, I don't know if I want to. Let's see. Yeah, no, I'm already kind of, well, let's see. I'll bring them in at the end of November. That's the earliest.
Okay, thank you, Your Honor.
November 30th. At 1:30. All right, with the following conditions, of course, you shall not violate any criminal law of any governmental unit. You must not leave the state of Michigan without consent of the court. You must make a truthful report to probation on a monthly basis. You must notify probation immediately of any change of your address, phone number, or employment status, and you must pay the following fines, costs, and fees. The court is going to impose mandatory costs of, this is on count 3, mandatory cost of $210. On count 4, mandatory cost of $185. And then on count 3, a $125 attorney's fee. A $500 fine. I read something about restitution. Hold on. That's what I meant to ask the people about. If I'm reading the right report, give me a minute. Oh, no, they said they didn't have any out-of-pocket expenses. Okay. Court sets restitution at $0. $35 per month oversight fees. Total oversight fees are $490. That's for the full 14 months. If you get discharged early at a certain point, then we would prorate those oversight fees. And then the $100 pre-sentence investigation substance abuse evaluation fee, the total fines, costs, and fees on count 3 is $1,425. And then the court is also going to impose a $200 fine on count 4. Total fines, costs, and fees on count 4 is $385. The total on both counts is $1,810. Now, if you become eligible for discharge after 7 months, then of the $1,810, $1,810 minus 2, you would have had to pay $1,565 to get discharged at the halfway point. All right. Additionally, you shall not use or possess any illegal substance. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume any alcohol in any form, whether it is a beverage, a Jell-O shot, a piece of candy, some cough syrup, no alcohol. You shall not drive without a valid license. You shall not use or possess any, strike that. You shall attend and complete the alcohol highway safety education level 1. You shall submit to random urine. He's on the alcohol tether. I'm going to take him off the tether. Has he had any violations?
I think so, Judge.
Let's keep him on the tether then. Alcohol tether. I'll keep him on until that first review so I can see if he needs to go to sobriety court.
Okay.
All right. The victims impact panel and the consequences video. Probation has recommended outpatient treatment, and I am going to order outpatient treatment. Outpatient treatment and a 12-step program. Of course, AA is the most known one, but it doesn't have to be AA as long as it's approved through probation, and it is a 12-step program. You will attend the driver's improvement program. You do have a balance with 36 District Court. You're going to have to get on a payment plan. So you're going to either get on a payment plan or pay them in full before the conclusion of your probation. It says you have a balance of $2,212. And then I am going to order choices. Now, if we're going to mail you a copy of this order to the Oakman Boulevard address, and probation will contact you at the phone number that ends in 4731. Oh, I apologize. Also, the court, of course, is going to order on count 3, 5 days in the Wayne County Jail, credit for 5 days already served. So he doesn't have to serve any additional days. All right. If you end up going to sobriety court, if you don't beat the struggle, and I send you to sobriety court, we're gonna mail you a copy of my order. But if I send you to sobriety court, the order changes, and some of this stuff that I ordered, it will no longer be in effect because I'm gonna need their program is a little rigorous, and I don't want to put anything on you that's gonna add extra stress to what they're doing. So if Judge Holmes doesn't order it, it's not going to be a part of your order. But right now, this is your order. And if you end up going to sobriety court, then the order will change, okay?
Okay.
You can do it, Mr. Lewis. It's hard, but you could do it. And so let's just see what we could get done. And then if not, we'll send you over to sobriety court. I don't think those things will disqualify him, but she will. Now she is going to consider the fact that he was unsuccessfully discharged. I think that's going to be hurt him more than those other charges that he has. So we'll see if necessary. We'll see what Judge Holmes says. Okay, anything further?
No, thank you, Judge.
I don't have anything on behalf of Mr. Lewis. Do you have anything, Mr. Lewis?
No.
Okay, thank you, Judge.
Mr. Lewis, then you're all set, sir. Have a great day. Stay safe.
Happy birthday.
And happy birthday.
I appreciate it.
Now don't celebrate, Mr. Lewis.
No.
Okay, Mr.
I already know what you're gonna say. No.
Have a great weekend. Have an alcohol-free weekend. Okay.
All right. I got you.
Whoops. All right. Ms. Stevenson, how should we proceed? I didn't figure out what I was going to do with Ms. Terry. Did you talk to the guardian?
I haven't made any contact with the guardian, and I usually can't reach them on Fridays.
Okay. Well, I think I know what I'm going to do with her. They won't take her. All right, we're gonna start out trying to get her some treatment, and we'll see how that works for us. So do we want to do Terry, or we want to clear out the waiting room and then do Terry?
It's really up to the court. Ms. Ritter probably wants to finish Miss Terry.
She probably does. And because it's lunchtime it's getting ready to be lunchtime at the jail too. So go ahead and bring Miss Terry out. Oh wait, we didn't do Irving. Did we do Irving?
No, Mr. Irving left the breakout room, and I think he's come back as that 360.
Oh, okay. So I'll do Terry Irving. Terry Irving. Phillips. Oh, Miss Ritter still got a couple on there. Terry Irving and Phillips. And then the only two, Miss Frowner is the only, oh, and Garrett. Frowner and Garrett, those are the only two reviews. All right, this is Khadijah Terry, case numbers 2145548. That charge is retail fraud. Case number 2145550, 45551, and 45552. And the people of the state of Michigan versus Khadijah Terry, those charges are malicious destruction of property. As to each matter, today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson on behalf of Ms. Khadija Terry. Ms. Terry, ma'am, please tell the judge your full name.
Khadija Terry.
All right, I didn't know the jail was gonna bring you in person, Miss Terry. Had I known that, I probably would have came down there, but nonetheless. All right, today is the day set for sentencing for Miss Terry. We actually have a PSIR for Miss Terry, don't we?
It wasn't completed.
Oh, okay. So with respect to sentencing, is there anything on behalf of the people?
Nothing on behalf of the people, Judge.
Ms. Stevenson.
Your Honor, on behalf of Ms. Terry, I'm just gonna, I know the court is very, very, very familiar with Ms. Terry and with some of the struggles that she's facing. As far as I know, there's no problem with her returning to Naomi's Nest. I do believe that some type of treatment regimen is going to be warranted. I just learned from an off-the-record conversation, although I've had conversations with Ms. Terry's relatives over the months that we've been working on her cases, have had conversations with Ms. Terry. I just learned that she probably is a legally incapacitated person yesterday, and that she probably has a guardian who should be present at court proceedings. I have some familiarity with that guardian, and don't believe that they're available on Fridays, that they take normal phone calls on Fridays. So I'm just asking the court to fashion a sentence for Ms. Terry, which is going to move her on the course of rehabilitation. I know she left Naomi's Nest because she had to be hospitalized. Then she spent some time at a different hospital and left that hospital. I don't know that she left against medical advice, but from my conversation with Ms. Terry yesterday, she does appear to have stabilized at least. She's indicated a desire to return to Naomi's Nest. I haven't known anything that I'm not aware of any factors which say she can't go back to Naomi's Nest. So that's really all I have at this time, Your Honor.
All right. Ms. Terry, do you want to say anything to me before I sentence you?
No, ma'am.
All right. So this is what I'm going to do for now. I think it's important that we locate Ms. Terry's guardian. As a legally incapacitated person, I do believe that she should have additional representation to maybe even enlighten us as to anything, but I don't know. Ms. Terry said that she has not been in contact with the guardian. I don't know the reason for that, but Ms. Stevenson, I do want you to try to locate the guardian. What I'm going to do is I am going to go ahead and sentence Ms. Terry to 24 months probation on all cases. This probation will run concurrently. It is my intention to also order initially at least 120 days of treatment. So it is my intention to order at least a minimum of 120 days of treatment. And right now, those are the only conditions I'm going to set out without having you have a conversation with her guardian and see if there's any other thing that should be done. I am going to attempt to send Miss Terry to Naomi's Nest. If for some reason that they reject her, then we'll have to try to send her somewhere else. So the court is going to continue Miss Terry, and her bond is, what is her current bond, Miss Silman?
Let's see here. $1,000 personal on that case ending in 548.
Well, don't even go through it. I'm gonna just do this. I'm gonna change all of her bonds to $1,000 personal bond if they are not already set there. Well, so she's under sentence, so quite frankly, there's even not necessarily a bond. However, and I suppose the jail would tell me if they can't do this post-sentence. I would like to tether Miss Terry to Naomi's Nest until we could speak to her guardian. So actually, maybe what I should do is adjourn her sentence. Maybe I should call it a sentence adjournment. I don't know if they'll let me do it, and I want her guardian to be able to find her. So when you find the guardian, I want the guardian to talk to Miss Terry. And I want to, I don't know who the guardian is. Maybe they lost track of her or something. I don't know, but Miss Terry says she has not spoken to the guardian. So what I'm going to do, I'm not going to say post sentence, but if the jail has an issue with me putting Miss Terry on a tether because she's been sentenced, then they'll contact me and I'll have to see something different about that. But I want her bond is oh, maybe I should do it like Judge Holmes do it. Maybe I should say that her bond is $1,000. I don't know how that works.
Bonds are personal bonds already.
I didn't hear you.
All her bonds are personal bonds already.
Okay.
1,000, and then one is 100,000 person.
Okay. So the bonds will continue on this probation case. That's where I'm confusing myself at. And I want her released only to Naomi's Nest. So I'm going to do the sentence in a different way. I'm going to say on the case ending in, let's just say on the case ending in 552, I am additionally going to sentence her to Ms. Stevenson, Ms. Ritter, let's run right quick to a breakout room. Let's go to number 15. Okay, the court is going to change its mind with respect to the sentencing at this moment. I'm going to adjourn the sentencing to Wednesday. Miss Terry's bonds will remain as they are with a GPS tether to be released to Naomi's Nest. So her bond is those personal bonds to be tethered to Naomi's Nest. Then once we get her to Naomi's Nest, I'll sentence her. But I think that's the only way I could get her to Naomi's Nest from the jail without them saying she can't go there. Okay, so that's what we're gonna do. And then by Wednesday, then you should have been able to reach her guardian as well. Okay. So Miss Terry, I'm trying to get you to Naomi's Nest.
Okay, thank you.
All right, so let's see if we can make it work. All right, I'll see you Wednesday.
Okay.
All right, July 19th, Wednesday, July 19th.
Judge, what time?
9 o'clock. All right. Ooh, yeah, it's lunch now, but let's hurry up so we can finish right quick. Bye. All right, I'm ready on Miss Stevenson. I heard Miss Stevenson was in the courtroom. Who did she said she think this person right here is Irving. You said you think this phone number thing, the Zoom ID number is Irving?
I think so.
All right, we have Irving, and then who else does, oh, and Phillips. I'll bring them both in. All right, Phillips came on screen first. I'm ready on Phillips. This is case number 204573201. The people of the state of Michigan versus Chantal, middle name may be Renee Phillips. Defendant is charged with 1 count of guns reckless use, 1 count of brandishing a weapon. Today is the date set for final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. Chantal Phillips. Ms. Phillips, ma'am, please unmute and tell the judge your full name.
Chantal Renee Phillips.
Today is the date set for final pretrial conference. How are we proceeding?
Thank you, Your Honor. Ms. Phillips will continue her plea of not guilty. We would ask this matter be set for waiver trial.
All right, the court is going to continue a not guilty plea. On behalf of Ms. Phillips, continue the matter to trial. With respect to the trial, Ms. Phillips, by her words, your lawyer indicates that you want to waive your right to a jury trial and have the matter heard by the court. Is that what you want to do, ma'am?
Yes, ma'am.
And do you understand that if I accept a waiver from you today, that the matter will be heard by me? I would be the only decision maker.
Yes, ma'am.
Has anyone threatened you in any way or promised you anything to get you to waive your right to a jury trial?
No.
Ms. Ritter, any objection from the people?
No objection, Judge.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts a waiver. I can set a waiver trial actually for, remember I said my waiver trials were done for the year, but I had missed one. And Ms. Ritter, do we actually? Never mind. You probably don't have the records for that. You have a bench trial with Mr. Upshaw, October the 26th. I'm wondering if that's going to really go, but I can set it for October the 19th, Ms. Phillips.
Okay.
Is that acceptable to defense and the people?
That's fine for the people, Judge.
I'm for defense, Your Honor.
All right. Bench trial, October, I said 19th, right?
Yes, Your Honor.
Good. And then are we asking for a final pretrial or a 12 noon check-in? Well, still, it's going to be a 12 noon check-in, but I requested another final pretrial.
Judge, I think the people are fine with the 12 noon check-in.
All right. Ms. Phillips, this is how it's going to work. You're going to log into Zoom at 12 noon, not by 12, at 12 noon. And then if the people's witnesses check in and you are here and everyone is ready to proceed, then the matter will be actually heard at 1:30 p.m. at the court, okay?
Okay.
All right, anything further?
No, thank you.
No.
Nothing on behalf of Ms. Phillips. Thank you, Your Honor.
All right, we're all set, ma'am. Have a great day. Stay safe.
Yeah. Second.
Ms. Stevenson, can you change this person's name?
Yes.
This is case number 214527201. The people of the state of Michigan versus Leandre Ramon Irving. Defendant is charged with 1 count of child abuse, 4th degree. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Leandre Irving. Mr. Irving, sir, if you could remain stationary and unmute and tell the judge your full name.
Oh, hold on. I might have disabled the unmute. All right.
All right, Leandre Ramon Irving.
Now, that's not going to be able to happen. Now, first of all, you keep moving around and you putting your ear up to this phone. Now, this is really distressing to me.
All right, apologize for that.
It's distressing to me for a number of reasons. This matter is scheduled at 9:10. Mr. Irving has on a white t-shirt that is inappropriate for court. He is putting his ear up to this camera as if this is not at least his 3rd or 4th time appearing to this court. And by the 3rd or 4th time appearing to the court, most certainly Mr. Irving should know proper courtroom etiquette and decorum. But it appears to me that he does not. He has logged on this morning and has been inappropriate at every step. Ms. Stevenson, how are we continue? But in the future, if you had your clients come in with these undershirts on for court, I'm just going to delete them. I'm just going to delete them out.
Yes, Your Honor.
How are we proceeding?
Your Honor, we would continue the matter, continue our jury demand at this point. I think there's a jury trial scheduled for November 28th, Your Honor.
And Ms. Ritter, will the people be ready to proceed? It seems like I must have wanted the people to confirm their witness if the trial isn't until November. You said November what?
28th, Your Honor.
I don't even have that written in my book. I have Boykin, 3 cases, but Miss Seelman, can you confirm that Mr. Irving's case is on November 28th?
Checking out.
Ms. Ritter, I feel like if I set a final pretrial this early, the people were supposed to confirm the witness. Do you have any information on that?
So, Judge, I'm looking at my notes, and the victim advocate's notes. So, the complainant witness, who the minor child of Mr. Irving, has not appeared at any pretrial conferences, and it looks like, according to the notes, we don't have any contact information for the complainant witness. So
I mean, who, okay, when the police submitted their information, who did they put down? They didn't put down anybody to say, this who has, the child is in the custody of this person right here, and this is their contact information?
Well, on the police report, Judge, there is a listed address.
I need the police and
believe the
everybody to do
number.
better. Okay, I need everybody to do better. Okay, so there's an address, but no phone number for an adult who has care, custody, and control over the minor child. Has the OIC or anyone gone out to the address?
No, Judge, there has not been any attempts made to the location, but the phone number we have, Judge, it looks like Victim Advocate Services tried to reach out to that phone number, but they did not get an answer.
Well, let me say this. I quit. I quit on Mr. Irving. I quit. He has to come in person. I quit on him. All right. We're gonna adjourn the case. Mr. Irving has to come in person. Let's see. Monday, July 24th, Mr. Irving has to come in person. And Ms. Ritter, maybe by that time, the OIC or somebody can go out to their house.
Yes, Judge, I'll get in contact with the OIC to make location or to make attempts to the location again, Judge.
In person only, in person, and properly attired. No shorts, no flip-flops, no beater shirts and stuff. A properly attired for court. Anything further?
Not from the people, Judge. Thank you.
Nothing on behalf of Mr. Irving at this time. Thank you, Your Honor.
I said, have a great day. Stay safe. This is case number 205684201. The People versus Shante Yvonne Frowner. Defendant is charged with controlled substance illegal use. Today is the date set for review. Appearance, please, Ms. Stevenson.
Janice Stevenson appearing on behalf of Shante Frowner. Ms. Frowner, ma'am, please unmute and tell the judge your full name.
Shante Frowner.
Your full name.
Shante Yvonne Frowner.
Today is the day set for review. Ms. Frowner was very late for court today. According to Ms. Tucker, she submitted a violation for Ms. Frowner. Ms. Frowner was placed on probation in February for 12 months. She has tested positive for alcohol on June 26th and July 3rd. And additionally, on July 3rd, she also tested positive for marijuana. She has not completed community service, and she has not paid her court balance. Ms. Stevenson?
So, Your Honor, at this point, I believe that if there is sufficient jurisdiction, that at this point, Ms. Frowner might be a better candidate for the sobriety court. And so
Miss-
we would ask for that referral if there's enough time yet.
Well, I mean, it should be, if I just put her on probation. This year, so it's definitely enough time. Miss Silman, well, let's let Miss Frowner come in person and talk to the sobriety court
Okay.
Monday. Miss Silman, can you call sobriety court and see if there will be someone to talk to Miss Frowner Monday?
Yes.
Tell them I want to bring her in person. And what's a good time for them to come and interview her?
Okay.
All right. Ms. Frowner, is there any reason that you cannot come down to 36 District Court Monday?
No, there's not.
All right. Then give us a minute, Ms. Frowner. I'm going to see what time they could talk to you, okay?
Okay.
All right. All right, I'm ready on Garrett. This is case number 194462002. It's recalled because I called it earlier when Ms. Garrett wasn't here. Ms. Stevenson, your appearance again, please.
Janice Stevenson appearing on behalf of Ms. Ayanya Garrett. Ms. Garrett, ma'am, please unmute and tell the judge your full name.
Unmute.
Unmute. Ayana Garrett,
What's your middle name?
Monet.
Ms. Stevenson.
So I am going to say, Your Honor, that that Ms. Garrett has been working with Dr. Alexander of CARE. She's been doing anger management with him. I think she met with him most recently last week. She would have met with him tomorrow, but for the fact that he asked her to reschedule due to her current physical condition. So I am going to ask the court to continue to work with Ms. Garrett, Your Honor. I know that
For
this
how
has been.
long? For how long? I'm wore out. I'm wore out.
Yeah.
I mean, I remember Miss Garrett. I remember when she came in person. I remember what she told me. I remember. But listen, sometimes you got to put some skin in the game, and you got to, we can't. I can't keep doing this. I'm not going to be. Let me tell you, it's giving Norman vibes. Okay, that's all I'm telling you. It's giving Norman vibes, and I'm not going to be able to do it. I'm trying to work with Miss Garrett. I'm trying to work with you, but I'm not going to be able to do this. There are some things that no matter what you're going through can be obtained. Sitting up straight, coming to court, having your device, that it doesn't matter what a person is going through, unless they are just, paralyzed and got to lay down. Unless they're on bed rest and got to lay down. It's some stuff that can, I mean, I don't know why you doing that. That's what I'm talking about right there. I didn't ask you to show me your feet, legs, belly, or nothing. A part of your problem is you won't listen. You won't listen. I didn't ask you to prove anything to me. I'm making a statement about the fact of how you have been behaving all day. Whether or not your feet are on the floor, you are leaned forward with your arm to your face. It is inappropriate. It is inappropriate. When you come into the courtroom, you are standing straight up at the podium. Therefore, when you are on Zoom, you should be straight up and ready to attend court. But yet every single time, Ms. Garrett, I have to have this conversation with you, and you do not show any contriteness. You do not show, Judge, I'm trying to do it. Judge, it's hard. You always got a smart comeback and all of that, and I'm sick of it. I'm sick of it. I am sick of it. I'm sick of it. So this whole woe is me, and please y'all help me, but you're not cooperating with the help. I'm sick of it. This whole, my grandmother came, or my mother, I forgot who came. My grandmother came to help me watch the kids. You're sure not showing no appreciation. I'm gonna get it together because they came all the way here to help me. I'm here by myself. Seems like to me, if that's the case, then every time we come on here, it should be smooth sailing. The judge is giving me so much grace and mercy. I'm so thankful. I was gonna revoke your probation before, but yet here I am again, giving this same speech to you again. Well, let me tell you something. I'm not gonna care about your family more than you do. I'm not gonna care about your freedom more than you do. So we might go back to that original statement that you told Ms. McCall that you didn't want to do this and you just want to go to jail. Because guess what? I don't want to do it either. And I just want to send you to jail. So you're either going to come on here with a different attitude or that's what it's going to be. And you're not going to care and I'm not going to care. And it's just going to be two people not caring. Your client want to speak, Ms. Stevenson.
Yeah, I guess at this point, Your Honor, I think that the best thing for Ms. Garrett would be to prepare for that meeting with Dr. Alexander. And we would ask the court to continue the matter. I believe that based upon my last, okay, actually Ms. Garrett wants to talk, so.
Yeah, let her talk, unmute, let her unmute and talk.
You're saying no.
All I was just saying was the last time that we met, and I'm not making this a ability. Remind you, I kept coming back because I was unable to make those payments the way I was. You were supposed to set up some type of specialty court. No one never, ever reached out to me. I did all the researching that I could and got all the help that I could within an amount of time. But no one never reached out to me from the specialty court. So I never got no assistance.
I want to know what that had to do with Ms. Garrett in the court.
I'm not hemmed up. I'm on the back of a wall. I'm sitting on the floor. It's not that I'm hemmed up. My body is aching. My back and my body, I have COVID. My body is aching. I'm sitting behind the couch because I can't take the sunlight. Ma'am, I am going through something right now.
Me too. Me too. Me too.
And I really do apologize, and I really do appreciate the chances and the things that you have helped me do and kept giving me chance after chance. It's not that I'm sitting here begging for chances or I'm saying that I'm unable or I'm not capable, which I am able to do everything that you're asking me. And I'm trying, like I said, it was just, I never received the help that you said that you were going to allow me to help. You said that you were going to contact some specialty people. I never got those calls from those people, and I'm not using that as an excuse. I just really would have liked it, the extra help that you would offer me the last time when we were on Zoom.
Ms. Stevenson, I mean, I don't know where to go from there.
So in that she does have this relationship set up at this point with Dr. Alexander.
Is she talking about Mr. Patel? I don't know who the specialty people are. So that's what I don't know who the specialty.
I don't know whoever you said that you
I'm
were going
talking
to
to Ms.
meet up with
Stevenson.
before.
I'm talking to Ms. Stevenson. Ms. Stevenson, did I refer her to the street outreach court?
I don't think so, Your Honor. I think it was through whatever resources Ms. McCall would have available. I think that's where we're headed.
Let's just see if we can give Mr. Patel her phone number. Because Grace and Mercy running out. Let's give Mr. Patel. Let's give her Mr. Patel's phone number and give Mr. Patel her phone number. And I have not known Mr. Patel not to contact somebody, but it could be the case because no situation is perfect. And Mr. Patel could be getting overwhelmed, just like Mr. Rice is overwhelmed probably with all the people that I keep sending now. But let's just make it happen. So I just put her on in February. We got plenty of time. It's just, are we going to be able to take up the plenty of time? All right. Oh, Ms. Stevenson, I'm getting ready to send you this. I forgot to send this to you. Remember, it doesn't have anything to do with Miss. I'll tell you after we finish.
Okay.
All right. So when is Miss Garrett gonna come back to me? After I want to give it plenty of time for Mr. Patel to contact her, for her to contact Mr. Patel, and for her to continue to, I think Miss McCall must have referred her to this other person that you're telling me about.
Yes.
All right. Yeah. So let's get it done.
Are we? Oh, we are live. Okay.
Yeah, 90 days. Is
yes,
that...
please. Yes,
All right.
Your Honor.
90 days. Well, you have her phone number and stuff because she was texting you saying about the...
Yes, I do.
Situation. So this is July, August, September, October. October, let's come back October the... Want to do the 20th, October 20th or the 13th?
20th, please, Your Honor.
October 20th. And the only specialty people that I think Miss Garrett could be talking about is Mr. Patel. That's the only thing coming to my mind. Otherwise, she would be talking about drug court, sobriety court. And I don't think I was referring Ms. Garrett to sobriety court unless you have some different information.
Oh, I don't. And I know that there was even some, I'm just wondering about the street outreach court because there was some conversation about some type of special assistance, which Ms. Garrett indicated she wanted to work and take care of her family, that she didn't want to have any kind of public assistance or anything like that.
I already have found the job. I'm sorry to cut you off. Miss McCall got me hooked up with some temporary agency. I worked there for 1 week at the zoo, but due to my background, they said that I had to wait until my stuff came back because I had something pending. And when it came back, it was my probation. She said that I needed to get it written off because they really didn't allow people who were still on probation. You had to be either off of paperwork or a felon that already had got just like a closed felon or something, not an open case. You can't be on probation.
So that's probably why we never did send her to the specialty people, because she already had got a job and something else. Let's just connect her with Mr. Patel and let them work that out.
Yep, and I even got proof that I was working as well. I got a pay stub.
All right. October 20th at 10 o'clock.
Thank you very much, Your Honor.
You're very welcome. Have a great day. Stay safe. Have a good weekend. You wears me out, Miss Stevenson.
Your Honor, I've talked to probation and for Ms. Frounder.
Oh, Miss Frounder left. Miss Frounder gone. I don't even know. I forgot about Miss Frounder. Oh no, she in the breakout room. Who sent her there? Zoom be doing some stuff. Or maybe she would just went back there because she was tired of listening. They could talk to her when?
10 o'clock on Monday. And they want to speak to Ms. Harris. I guess she's the one that's be available.
Okay, so let me bring her back out. 10 o'clock Monday. We'll just have her come to us. And then that'll work out. Okay, the docket, that we can go off the live.